who is having some personal difficulty and which is not objected to by Ms. S. Jahan, additional PP. This is the matter after
Any day, Your Honor.
1 week, 2 weeks, 1 year. How much?
4 weeks, 2 weeks. I was not instructed as to it.
Okay, 2 weeks, 2 weeks.
Okay.
My please, Your Lordship. My lord, similar with regard to item number 15, my lord.
On the prayer made by Mr. On behalf of Ms. S. Burman, M. Burman, amicus curiae, same thing, huh? After 2 weeks.
Highly obliged, Your Lordship.
Item 12,
No, 15.
not 15 done.
Ah.
On the prayer made on behalf of
Mr. A. Bachcharya got it.
Mr. A. Bhattacharya,
He's out of station.
same, huh?
Lordship, can it be on the next Tuesday? 1st of August, Lordship.
What is the matter about?
Lordship, it is NDPS, 660 kilo ganja, Lordship, if you remember.
No problem. Next week,
Next Tuesday.
next Tuesday, this is the matter on.
Lordship, one more prayer, Lordship, your listing. The matter was last listed on 3/5/2023, and since then, Lordship, it has not been listed. The LC is there, the objection has also been filed. The next Monday, Lordship. Lordship.
Let's just matter at
Yes.
10:30.
1 to 3. Jail appeals.
No, at this item one. Oh, item 1. Item 1, okay. Right. This is a jail appeal filed against the judgment dated 23/5/23 passed by the Court of the Additional Sessions Judge -2 bracket FTC, Tinsukia in Sessions Case number 21 bracket capital T of 2021, by which the appellant has been convicted under section 302 IPC. Admit the appeal, call for the LCR. Ms. L. Jahan appears on behalf of the, appears on behalf of the state.
Vijita Sharma is there.
Ms. B. Sharma is appointed as the amicus curiae. This is the matter after 4 weeks. Jail appeals against the judgment dated 18/5/23 passed by the Court of the Special Judge POCSO Tinsukia in POCSO case number 197 of 2022, by which the appellant has been convicted under section 6 of the POCSO Act 2012. No, under 376.
376 not required, only POCSO service would be required.
Under section 376. IPC, under section 376 IPC. Admit the appeal, call for the LCR, Ms. L. Jahan, same thing. Who will be the amicus?
Rita Das Majumdar is there.
Ms. R.D. Mazumdar is appointed the amicus curiae. This is the matter to. This also jail appeal against the judgment dated 31/5/23 passed by the Sessions Judge Biswanath, in Sessions Case number 8/2020, by which the appellant has been convicted under section 302 IPC. Who admit in call for LCR? Yes,
Azad Ahmed keeps doing.
Mr. A. Anyone else? Ahmed has got number of cases.
Nobo Kumar Kolita.
And
NK
Okay,
Kulita,
Mr.
Mr.
Mr. N.K. Kalita, huh? Is appointed as the mic. Yes, heard, Mr.
V. H. Chaudhary.
V. A. Chowdhury, learned counsel for the appellants who submits that the impugned judgment dated 31/5/23 passed by the Court of the Addiction Section Judge number 3, Common Nagaon, in sessions bracket T-1 bracket close case number 47 bracket capital N of 2015, by which the apparents have been convicted under section 302 IPC to be set aside. Admit the appeal, call for the LCR. Ms. El Jahan, appear for the state. This is the matter of the court.
Highly obliged.
In fact, the service is not completed. I could not be complete because of insufficient address, it is said. The office note shows the address is not sufficient. Address I have given, it is within Guwahati itself, Dokhin Horonia, Polton Bazaar. In fact, Mr.
Unless there is
Bora.
a house number, it will be difficult.
In fact,
Um,
Mr. Bora appeared for him during the trial. I was telling him to,
Oh,
but then,
Anshuman,
yes, Mr. Angshuman Bora. And then he says, unless the notices and I'm instructed, how can I? This
you
is
can
also-
ask him for the real address or the phone number or
Yes, of
something.
course. Mr. Chaudhary is there, if he can help me out.
I don't know, that is
Otherwise-
between you, we have got nothing to
Yes.
do, we're just giving a hint. That maybe,
Hmm.
you know, he can ask the house number or
Yes, of
something.
course.
and then
Because the only address that I could gather from the FIR is this, as well as in the,
Without
judgment.
house number, how will you?
how will, so I'll
Not
take
possible.
their help and I'll again take fresh
Okay, right.
steps.
Mrs. Jahan, learned additional PP submits that as per office note dated 18/7/2023 and served notice has been received back with the remark inverted comma insufficient address. She accordingly prays for some time to obtain the correct address. To obtain the correct and full address of the respondent. Prayers aloud. Ms. El Jahan will
Fresh steps. will-
take fresh steps for service of notice upon the respondent on obtaining the correct and full address of the respondent within a period of,
2-3 days.
within a period of a week, within a period of 1 week. This is the matter after 4 weeks.
No.
Meet with the lordship. And Lord, it's a criminal appeal for 302. We have
Paper-
made the paper book.
Paper book is
Okay,
ready.
paper book is ready.
Hmm.
Madam.
Have you got the paper book?
Yes, yes.
So
So a date
how
of.
come yours is so thin and mine is so thick?
It's one-sided and it's both-sided.
Okay, okay.
Both sides.
For lordship, it is always one-sided and for us, it is both-sided.
The
And-
perks, the perks of being a judge.
On the prayer, my lord, is it may be fixed for a hearing at the convenience of lordship in early date. Because there is lots of lacuna in the judgment. I have said that the murder weapon, which has been seized, that has been seized from a different person. And that has also not sent to the
Citizen.
uh, for, I mean,
Examination, forensic.
forensic.
FSL, FSL.
Yes. And there is also, my lord, no eyewitness. That is only circumstances. They are also very weak in the connections.
Anyway, I don't know.
Appellant is a little unwell also. I mean, I got an instruction from the jail authorities on the basis of the
How
eye
old
that
is
was.
the appellant?
He is quite old, 73 something.
Yes.
Oh. Okay, when do you want?
Right.
When? After?
August last or second week.
When? August? Second week?
21.
One on the
August second week,
No, when you give a date. You give a
16th
date.
of August,
Huh?
16 August,
16 to 7.
oh, but
August, sorry.
23rd August.
My lord.
Okay, right. Mr. A.C. Buragohain, learned senior counsel. And Ms. L. Jahan, additional PP. Submit that as paper book has been received by them. The matter may be listed for hearing on 23rd August. This is the matter on 23rd August.
Okay.
For hearing.
Medical or
In item 7, a few
like
Calcutta
something.
advocates from Calcutta comes. In the, on the earlier occasions also they came.
Now
But
today,
they informed me that they couldn't come today.
Ah.
So they'll be here on 1st of August. So they have prayed through me before your lordship that the matter may be fixed on 1st.
You-
My objection is also there in it's on record.
My lord, one
Huh?
pair. my lord,
Oh, the earlier matter.
item 6.
Item 6.
Ah.
What happened, my lord, he's suffering, this man, he said. So if your lordship directs to get him examined medically in the.
My lord, he has a kind of like a stolen, they sore inside his throat. The client is that they are apprehending that it might be a throat cancer. So that's why we want to get it properly checked. Because he can't take any solubles right now and he's completely on liquid diet and holding.
Okay, you just write again.
I got a medical report on the earlier
No,
occasion.
no, this time. this
But
is suffering.
yeah, it was
Okay,
long
right,
back. It was around 2 months.
A.C. Buragohain, learned counsel for the learned senior counsel for the appellant. And Ms. L. Jahan submit that they have received paper book. And accordingly, the matter may be listed for hearing on 23 August 2023. Mr. Buragohain also submits, no, this, the senior counsel also submits that the direction may be issued to the respondent authorities, to the jail authority,
Jail of it,
to the jail authorities to have the appellant medically examined
in the medical college there.
Huh?
Assam Medical College, Dibrugarh.
in the
He's in
Assam,
Dibrugarh.
medically examined in the Assam Medical College, Dibrugarh,
Yes.
in as much as the appellant is having a what lump.
He's having a sore throat and he can't swallow. He cannot take-
In as much
No
as
problem.
appellant is having sore throat and cannot swallow food. Full stop.
Perhaps he was already treated. He has been getting treatment.
Full stop.
so-
Considering the prayer made by the senior counsel for the appellant, the jail authorities shall take steps for having the appellant medically examined with regard to his with regard to the problem with his throat. Expeditiously. And provided that the same has not already been done.
And the report may be sent if your
Full
lordship
stop.
wants.
The report regarding the medical examination of the appellant shall also be submitted on the next day.
Obliged.
This is the matter on 23.
7 lordship has fixed it on 1st of August. and
Okay,
7.
right, Ms. L. Jahan, additional PP submits that the counsel for the appellant
From Sengupta.
is from Kolkata. And she has been informed that they would not be able to appear today in court. He submits that the counsel for the appellant had requested that the matter may be fixed on 1/8.
1st of August.
Accordingly, come on, this matter on 1/8.
Lordship.
Hello, item 8, Lord. That's it.
Let it come. You have reached the bus stop, now wait for the bus to come. Now this is the bus.
Lordship, matter will be fixed on Monday, Lordship, but my senior is not there today, Lordship. It's just, I have for bail is there, Lordship.
My objection is also on
Also fine,
record. I
Lordship.
said.
We have received the objection, Lordship. Kindly fix it on Monday, Lordship, on 31st.
Monday.
Has the paper book been made?
No, paper book has not been made. LCR is here. It is in the process perhaps. Not a very old matter, 23 matter.
Ah,
See, I have for bail is there. Lordship.
What is the matter about?
It's a matter,
I forgot.
convicted under section 302.
No.
Of the children.
So any eyewitness? Any eyewitness?
No, I.
No, no,
Lordship.
Circumstantial evidence.
302 years.
So that Trimuk Maruti Kirkan case has probably applied.
Oh, it's
Inside the house.
witch hunting.
Huh?
It's
Witch
witch hunting. It's suspecting her to be a witch, took her to the house, assaulted her. Was taken first to the local hospital, then to Lakhimpur, and she succumbed to her injury.
So you want it on Monday to, for what? On the IA?
For IA, Lordship.
Have you filed your WO, madam?
No,
It's
Lordship,
fine.
yes, I filed
Can
We have
it.
received, Lordship.
I filed it.
What is your name?
B. Borgunhai, Lordship.
B.
Borgunhai.
Mr. B. Borgohain, learned counsel for the appellant, prays that the matter may be listed on Monday, 31st, on 31st. For hearing on the IA. For hearing on the application for bail and suspension of sentence. Combined as matters, his senior is not is having some personal difficulty today. Ms. S. Jahan does not have any objection to the same and submits that she has submitted WO in the IA.
Aye.
So accordingly, list this matter on 31st.
Much better.
Are you called? Okay, then you call later. again. Your call
For the High Court.
in 1670?
Yes, the contempt matter. The suo motu contempt.
Okay. That, why are you here? Why are you a party?
Because the suo motu contempt has been initiated by this honorable court and
Well, I think we'll let us wait for that for some time.
my lord.
Because if they don't come, we'll have to probably issue warrant of arrest.
Warrant, yes, my lord, that's what has.
Let's wait for some time. Huh? Huh? What happened? Oh, Miss Jahan. You see, there is on 1st of August,
Hmm.
we have already fixed one DB matter.
Acha,
I mean, civil case,
acha.
Harit appeal.
Okay.
That will take, I think we have already figured item 1 in the
Oh.
hearing this. And that will take, I think, the whole day.
Acha.
Good.
Then I'll tell them to come little late, second, third.
So I don't know. So we do not know what date will be convenient to them.
Oh, yes.
You see, because now they'll have to change their flights and maybe
Uh-huh.
those things are there.
I'll let your lordship know. I'll talk to
Yes, you
them.
talk to
and
them so that we might have to change the date
yes,
because that will take
Oh,
it takes some time.
perhaps that High Court matter.
High Court matter, yes, High Court matter where Mr.
Appoint-
Chowdhury, Ken Chowdhury,
Yes.
Mr. Nair
Hmm,
and all those.
all those concepts, okay. On rules, High Court rules, yes.
Look, in these matters, if I may be permitted to go and conduct some other matter,
Yeah.
my colleague will,
Yes.
I'll be here. Obliged. Item 9.
That is your lordship. Lordship can peruse the last order dated 18/7 to 2020.
Just take us again to what was their issue. Because we forget, every day we are on the issue of PW 1, 2, 3, 4 weeks, we get confused as to which case is which.
My
Yes.
lord, the informant lodged an FIR
Yes.
which your lordship will find at page 4
Yes,
on 3rd of April 2010.
FIR on 3/4/2010 by PW.
She's PW
Four.
4,
She is the, any
She is the
relation, mother,
mother of the victim
mother of victim,
And mother-in-law of the accused.
and mother-in-law of the accused.
mother victim and mother-in-law of appellant. Then,
She lost the affair saying that yesterday, that is on 2nd of April 2010, the accused person demanded 10,000 in cash from her daughter, and the accused person poured kerosene on her body and set her on fire with intention of killing her. As a result, my daughter has been undergoing treatment at Dangtol Railway Hospital, and I am thinking to taking her to nursing home in Coach Bihar for better treatment.
thinking of taking her.
To Coach Bihar.
Did we make any note? Did I?
Yes, probably there,
Yes,
probably
just
your
get this
lordship,
part out, your lordship.
it's part.
No, did I make any note? Did I give
Probably-
any,
18/7
statement.
last listed, 18/7.
did I give any,
No,
did
I
I
don't think so.
pass any order?
No, no. That's only regarding this, the order was passed. That on hearing the counsel for the parties,
Ah.
there appears to be discrepancies not only with regard to the date, but also the time of death of the disease.
Okay, thinking of taking her to Coach Bihar.
Coach Bihar. So on 3rd of April 2020, 2010, he says two important things.
Yes,
The first one is that the accused person has poured kerosene on her daughter. And the second thing, that she is thinking to taking her to Coach Bihar for better treatment.
yes,
Now, there is one eyewitness, their son, who is 9 years old,
page,
page 13,
PW,
PW 3.
son. So that means the grandson of the
Informer.
Yes,
Now, he says the incident took place on 1st of April 2010, not on 2nd of April 2010.
yes,
Now, the informant, during her cross-examination, that is PW 4,
page,
page 17.
yes,
She says, I did not mention in the Ejahat that Pratima had told me that her husband had set her on fire. Only after lodging the Ejahat, I heard about that from my daughter. So before filing of this FIR on 3rd of April at 10:30 PM, I will come to that where from.
just a minute, let me go again to the FIR.
Yes,
FIR,
page 4.
yes,
He says yesterday, that is on 2nd of April.
came to know it from phone. This is demanding money.
Yes. And accused person poured kerosene, and she wants to take her to Coach Bihar for better treatment.
No, but then this portion that she poured kerosene, that kerosene was poured, that was not said over the phone. Oh, the only thing that was said over the phone was that there was a demand for 10,000. You cannot link up the two because there's a full stop in between.
My lord, may I just read an entire, because I am also getting confused because of the dates. Humble submission is that about 10 days ago, the above mentioned accused person married my below mentioned daughter as per social customs by taking dowry. and 2 sons were born to my daughter out of this marriage. But after a few days of their marriage, the said accused person started to torture my daughter for dowry, and my daughter informed me it over phone. Full stop. Yesterday, that is on 2nd of April 2010, the accused person demanded rupees 10,000 in cash from my daughter, and I came to know about it over phone.
Now who informed her? Who informed?
No, but
we do not know.
not mentioned, not nowhere it is mentioned. As my daughter refused to bring the money, around 2 p.m., the accused person poured kerosene on her body and set her on fire with the intention of killing her.
So
So-
this is all, we do not know who told her.
Who told her and how told her, but it was written by way of an FIR on 3rd of April 2010.
Yes.
Now, here during cross-examination, she says that only after lodging of the Ejahat, I heard about that from my daughter that the accused person poured kerosene on her. Now the investigation
So how does
officer,
this, where is the anomaly?
yes,
She heard it from some XYZ.
maybe, but the anomaly
at
is
the time of
regarding
filing the FIR.
regarding the time of filing FIR and the time of death of the victim. Now, in the judgment also, the the PW6, who is the first IO, page 21.
Yes,
Page 21, he says on oath that on 3rd of April 2010, I was working as in charge North Bongaigaon PP. On the day at about 10:30 p.m., one Srimati Namita Roy, wife of so-and-so, PS so-and-so, Coach Bihar, lodged and written FIR at North Bongaigaon PP stating that her daughter Pratibha Burman was married to Karlan Burman about 10 years ago. So the FIR was lodged on 3rd of April at 10:30 p.m. And now, if we take up the inquest report, page 68, which was made at Coach Bihar, not at Bongaigaon, page 68. Here, the date and column number 3, date and hour of death.
when made on which date?
It was the date is not mentioned here. It's a typed copy. I have a typed copy, but date is not mentioned.
So it will be in the original, what is written?
Inquest
Original
report.
document.
Lordship,
Yeah.
may not take into account the inquest report because I have gone through the records and Lordship, in persons of your Lordship's order, earlier order, copy of the case diary as well as exhibits were provided to me. Lordship, inquest report is not a part of the exhibit. It has never been exhibited. So your Lordship,
Never exhibit.
yes.
Why?
And there is discrepancy regards it. So your Lordship, I took indulgence from this honorable court so that a copy be provided to me. I have gone through the records. Lordship, I think it's in synchronization. It's in sync, my.
But then,
It was never been exhibited. Copy of the inquest report.
anyway, let us see, never exhibited.
Lord, still I'll have a look at the original.
Yeah, let us see inquest report made in Coach Bihar, volume 3, the serial number 3. Date and hour of death. Date. Three, 4, 10. 705. Yes,
So this, as per this inquest report, she died on 3rd of April at 7:05 PM. And she files an FIR at, she died at Kuch Bihar and she files and lodge an FIR at Bongaigaon
10:30,
at 10:30 PM,
saying that she.
saying that she wants to take her to Kuch Bihar. Now, another thing is that no person, no medical officer, no,
Who made the inquest report?
this was made,
Author also not examined as a witness.
it was made by reference, under reference Kotwali PS UD case number 142 of 10 dated 4/4/2010. Author
I.
ASI Lumira Rai, Kotwali PS CBR. Last one.
No. Witnesses are present.
No, she was not also been called as a witness.
Was he made this Lumira Rai is a male or a female? Probably any, whatever he or she might be. Now, he was not made a prosecution witness.
Not
No.
In the list of witnesses also. it was there.
Then where she first taken to for treatment, that is the Bongaigaon Railway Hospital.
Zangtol Railway Hospital.
Yes, that is Dangtol Railway Hospital is Bongaigaon, that's Bongaigaon. Therefrom also nobody was called for as a prosecution witness.
Acha. So no doctor,
No doctor. Only the medical officer who conducted the post-mortem, he was called for.
so who is this person who made the PME report? He's from
He is from Coach Bihar.
Acha, he's so he's a doctor.
He is a doctor.
Doctor
PW7, he was called for.
PW7. Page,
Page 23,
doctor from Kuch Bihar.
Coach Bihar.
Which hospital?
MJN Hospital, Coach Bihar.
MJN.
N.
Where she
Hospital.
died, ma'am.
So not even taken to the nursing home.
Now, let us read
No, no, just
the
a minute.
PW7 mandate.
Because anyway, PNJN Hospital, Doctor. Yes,
Yes, let us see the PW7 manner.
this. Page 23.
23. On 4/4/2010, I was posted as medical and health officer at MJN Hospital, Coach Bihar. On that day, I conducted postmortem examination on the dead body of Pratima Burman, 29 years female, New Bongaigaon Railway Quarter, on being identified by Constable so and so in connection with Kotwali PS UD case number 14210, dated 4/4/10, and found as follows. External appearance, an average build female body. There was superficial burn injuries on the whole body, excepting the face and foot. Now, the next page, his opinion. In my opinion, the cause of death was due to shock from the above stated burn injuries, which was antemortem in nature. Exhibit 5 is the postmortem report, wherein Exhibit 5(1) is my signature. Now, during cross-examination, he says, in the report, I have not mentioned the percentage of burn injuries. Without advice and consent of the doctor, if a patient party takes away the patient from the hospital, responsibility lies on the patient party. As per record, the deceased was admitted in MZN Hospital, Coach Bihar. In my report, I have not mentioned the time since death as well as age of the burn injuries. But the other witnesses says while she was taken to the hospital, she expired
On the way to the hospital.
on the way to the hospital. Both the PW1.
No, you see, one thing I'm quite slightly feeling surprised with is the fact that it says that these are superficial burn injury. Now, what do you understand by the word superficial? Superficial cannot be serious. It's just a superficial.
But as a result of that injury, she died, madam.
How can it be? That is what.
Because on
Please-
next
please-
day,
Please understand the word superficial.
superficial, the other day.
Yes, please give the dictionary. Superficial means superficial. It's not a grievous injury. It's a very superficial injury. Superficial is no, it's just a minor injury. Just on the outside, not deep. SUPER. See, existing or occurring at or on the surface. The building suffered only superficial damage, situated occurring on the skin or immediately beneath it. So, appearing to be true or real only until examined more closely. So you see, like if you say the building had a superficial damage.
But she got a shock out of that burn injury.
We do not know.
No, she, as per the opinion of the doctor,
Huh?
cause of death is due to shock from the above stated burn injuries.
The doctor has not stated the percentage of burn she got.
No,
So she has-
superficial is it is like this. It's only on the outside. Supposing we say that, you know, that the building was burning and on inquiry it was found that it was only superficial burning. Which basically could mean that only the paint was peeled off because of the burn or something. So basically, the immediate thing is that it is not a deep or a deep injury or a, you know, very serious injury. It's only an injury on the outside.
And the medical officer should have indicated the percentage of
Yes.
burn.
You see,
So that-
yes, sir, you see, that way shock can be for anything. Someone walks and falls down. He died because of the shock of falling down. That's
True,
so.
yes.
So that can be there also. Anyway, but then that is highly unlikely. That's what I'm trying to say. It's highly unlikely that a person will, you know, from superficial superficial burn will die. Shock. Well, how do you define shock then?
No, she words of the medical expert cannot be the last word. The prosecution could stand on its own legs. As the doctor did not mention the percentage of burn, Lordship it will not nullify the prosecution case, your lordship. Here, the eyewitness, the son of the victim as well
What
as
about the time? of
time
death?
period, I have, let him complete, yeah, I'll satisfy your lordship.
And what about the inquest report? Why has it
Because
not?
they did not exhibit,
Why? What was the reason for not exhibiting? Is there, is the prosecution trying to hide something from the court? That implication can come. That inference can arise.
non-exhibiting the inquest report because other documents have been exhibited, your lordship.
No,
FIR as
but-
well as postmortem which are the vital documents for the prosecution. It has been exhibited.
No, you see, the most, according to me, one of the most important witness will be the witness in the Dangtol Railway Hospital. The deceased was taken to that railway hospital in Bongaigaon, first of all.
First of all, she was taken there
Now,
and thereafter,
where is the doctor who examined her? No doctor examined her.
no. But in fact, the other one of
Then who
MNG,
told them that no, she has to go to, it'll be better to do it in Kuch Bihar or something? Where is there evidence that they were not examined or they were not examined? You see, because if she was having an injury,
well,
then they first of all, what happens if it's a serious injury?
my lord,
They will go to the casualty department.
Yes.
No questions asked, they will go to a casualty department of a hospital. Now, if it is a serious injury, they will go there. And then maybe that hospital will tell them, we cannot look after, please go to this hospital. Now, in this case, this is a superficial burn. If you say it's serious enough to cause death, then the doctor in Dangtol Railway Hospital should have examined.
Right.
That has not been done. Now, for a superficial injury, why should you go to another hospital? Because if it's a superficial injury, because it's a minor injury, it's a minor issue.
In fact, the second IO, during his cross-examination, he admits that fact that he did not collect any medical report in connection with the treatment of the deceased in Bongaigaon. It is not a fact that I submitted the charge sheet against the accused without having sufficient.
That is why probably the lady died of shock,
yes.
but
so it's
maybe not because of the burn injury. Maybe something else. And that is why to make out a case for whatever reason, maybe they want to push behind. Because if it is a minor injury, if it is a superficial burn, it's only on the outside. It does not really endanger the life of a person. There was no need to go to Kuch Bihar. If it was, yes, percentage of burn is very serious. They cannot treat it in Dangtol railway.
She
Hospital.
died on the next day on the third.
Whatever, but they were, why should,
Second day is the date of
if you
occurrence.
have a superficial injury,
I understand your lordship.
why should you go to Kuch Bihar? That could be treated in that railway hospital. Not even, maybe in a primary health center also. It can be done. A superficial burn, you just put burn all, even or something like that, they would have told you. And no, that's just questions are being asked.
Well.
It's not that we're deciding, but these are the issues that
Yeah.
immediately crop up. If it's a
Well.
superficial burn, why do they have to go to Kuch Bihar? If it is a serious burn, then it is okay that she goes.
There
But it's
also
not.
this Bongaigaon medical.
Bongaigaon, there's no
After in this
doctor.
case,
hospital.
neighbors were also examined. Neighbors, my lord, they have given evidence in the support of the prosecution case. PW1, Sopna Day, immediate neighbor.
Okay, let us see. Now, anyway, have you finished or what?
My lord, in the 313 statement of the accused, the last question was put to him on page 31.
Yes.
Page 31. Question number 12.
Yes.
do you have anything else to say? He answers that I was working in railway. I never demanded dowry. I have found my wife having some relation with other person and I prevented her. Their boy's name is Bapi Chaudhary. The Bapi Chaudhary is the
PW2.
PW2. In my absence, he used to come to my house. There was unrest in the relation. I even informed my in-laws. On the day of incident, in the morning, I had a quarrel with my wife. I went to market in the morning. During the day time, in my absence, my wife herself set on fire. I was informed by one of my railway staff. I came home, the door of my house was broken. My wife was taken to railway hospital Bongaigaon by my neighbors. I went to the hospital. I saw my mother-in-law in the hospital. She came from Mathabhanga, West Bengal. I asked my mother-in-law to take my wife to Lower Assam hospital, but they did not hear me and took my wife to Coach Bihar. And on the way, she died. Out of fear of my life at West Bengal, I did not go with them at that time. On the same day, they had taken my wife. Had my wife been admitted at Lower Assam hospital, she would have been saved. Had I been such person, I would not have maintained married life with my wife for 15 years. I have 2 sons and I am worried about them.
Now, he was informed by one of the railway staff. Who is this railway staff? Then, where is your defense witness that you were in the, you were in the office at this
Key
time?
of LAB was
Huh?
not taken,
Then,
not proved. But the prosecution witnesses, that prosecution witness, that Bapi Roy and the eyewitness, that is his own son, they made a statement that this incident occurred on 1st of April 2010. Both of them, not a single witness or any typographical error, nothing there. They specifically said,
so there is no inquest report as to the time of death. Postmortem examination, anything with regard to time of death?
no. There are much lacuna in the this investigation. And the prosecution witness number 1, whom my senior friend is relying, that's the neighbor. She also during cross admits that I do not know as to how Pratima Burman caught fire.
Huh? PW?
PW1 and PW2.
Actually, she, how will she know? She
No,
was not there.
in
She was not an eyewitness.
she was not an eyewitness.
So who is the eyewitness? Son?
Son,
Son,
Ah.
PW3.
PW3.
Now, why should he tell a lie?
Probably a suggestion was given to him that he was tutored. He was 9 years
Tutored
old.
by whom?
It's a grandmother.
Anything else?
But may I just indicate the 164 statement of the son?
164.
Yes. Page 49.
Yes.
I'm skipping page 50. I'm reading the last 2 paragraphs. Pratima Burman is my mother's name. Kalyan Burman is my father's name. My father consumes liquor around 3 p.m. on the day. Some
13 days ago, my father came home in an inherited condition and asked mother to cut tomatoes. When my mother refused to do so, he assaulted my mother and set her on fire by pouring kerosene on her body in the kitchen. We poured water on her body in order to extinguish the fire. My father fled after he set my mother on fire. My mother was taken to railway hospital. Later, she was taken to Coach Bihar. My mother died on the way to Coach Bihar. It was about 6 days since the incident. So from the date of incident, he was under the custody of the informant, that is our grandmother. That apart, then also he has wrongly stated the date of occurrence. That is 1st of April 2010. So, my lord, the investigation made by the two investigating officers, in fact, they have not brought in any prosecution witness to prove that she was actually burnt by the accused person, or the medical officers at the Bongaigaon Railway Hospital, they were not brought as in witnesses. Even
But why didn't you question the witnesses? On that score, the IO.
yes, I have a question, my lord. They were questioned. May I just read the first IO's page 22, the cross-examination.
Yes,
Page 22. I had not seized any articles from the place of occurrence, but when I visited the PO, I found smell of kerosene. I had not seized wearing apparel of the deceased. The cause of delay in filing FIR is not mentioned in FIR. It is not a fact that I did not send the witness Bapi Chaudhary, Sapna De, Krishna Sil, Dipali Dev Roy, Rahul Burman for recording their statement under section 164 CRPC. It is not a fact that Rahul Burman gave statement under 164 statement as tutored by us. During my investigation, I had not examined the concerned medical doctor of Dangtal Railway Hospital and also not collected the medical documents in respect of treatment of deceased in Dangtal Railway Hospital. It is not a fact that I had not investigated the case properly. In fact, the second IO during his cross, page 20, page 20, the second IO's cross examination, he confirms it. I did not collect any medical report in connection with the treatment of the deceased in Bongaigaon.
so he was treated, was he treated? Was he treated in Bongaigaon?
She was admitted.
I mean,
She was admitted
She was
because the IO, first IO,
Ah.
the last line, page 21,
page 21, yes,
the last line of page 21,
yes.
the local people immediately admitted the injured at Dangtal Railway Hospital. So the IO is aware of that fact.
The first IO is at page 21. Okay.
Yes. And the second IO is at page 19.
No, he was not sure, maybe she was not treated. But just admitted that they were taken on the same day.
But we look at PW,
Sorry.
not PW, was in FIR. It is at the-
Mhm.
that means it takes it to the PW. So that means some who was there. They have been there for 2 times. That, when was the FIR submitted, what time?
My lord, this is evident from the PW6, the first IO.
It says what?
On 3/4/2010,
at 10:30 PM.
10:30 PM.
An incident occurred at,
124.
at what time?
That is not been mentioned in the FIR.
Around 2 PM, I think.
Yes,
Around 2 PM.
Around 2 PM.
Yes.
So the victim was there in the, according to the FIR, should have been in Dangtol Railway Hospital for
Exactly.
around 8 hours.
Because,
Since 2nd of April,
Since if it happened at 2 o'clock,
my lord,
the incident, FIR submitted at 10:30 at night,
FIR is on 3/4,
3/4.
3/4.
So
next day.
next day, FIR, that means has been in Dangtol Railway Hospital for more than 1 day.
Since 2nd of
Lordship,
April.
because from Bongaigaon to Kuch
No, please understand the
My lord.
question. Deceased was burnt on the 2nd at 2 PM in the afternoon. FIR lodged at 10:30 PM the next day. That means more than 24 hours have elapsed. And in the FIR, it was stated that she was going to take the injured to
Coach Bihar.
Kuch Bihar. So for 24 hours, the deceased was in Dangtol Railway Hospital, minimum of 24 hours. It cannot be said that the disease was not treated or not looked at. That is not a case.
Yes,
And in fact,
and your lordship,
so
this
where is
lady,
the- where is the, so isn't it crucial, the evidence of the doctor
I
who
understand.
looked,
Yes, my lord, yes,
that
yes.
is what I'm.
Yes, yes. But your lordship, this lady, mother of the victim, she doesn't, she used to stay somewhere else, right? It will take
In
also,
West
it will
Bengal.
take some time, yes, from West Bengal to Bongaigaon. It will take some time to arrive there. And after arrival in the hospital, she was on, referred by the
So-
doctor concerned, she was taken to Kuch Bihar.
So whatever it is, she did not go straight to the police station, or she went
No,
straight to
no,
the,
no.
she went first to the hospital.
Yes,
So she saw her daughter there. And then only she decided that she'll take her to Kuch Bihar. So for more than 24 hours, that injured person was in Dangtol Railway Hospital. No, it has to be. Because the local people, you cannot, the
first there
evidence,
was a GD entry, then thereafter logical.
evidence shows that the local people took that
Yes,
lady to
yes,
hospital.
and she was informed.
And normally people will not wait, let us wait for 20 hours, then we'll take her to hospital.
My
They'll
God.
immediately take her. So
Immediately, so the condition of the victim was serious, that's why she was immediately.
but if you are serious, where is the doctor? If she was in a hospital for more than 24 hours, some doctor would have treated her.
So shall I see
How
the
is that?
case that if I could find
Please,
out
please.
something medical. medical
After
report?
2 minutes,
So it was not exhibited. madam.
whatever it is.
Yes, ma'am. Medical account number.
Nine,
ডিটেকটিভ কইছে 1 তারিখ বলি তাই কইছে 2 তারিখ কাপিল চৌধুরী এইটো যদি হল নেকি পাইব মোৰ যাব হ্যাঁ আৰু বস্তু
মানে বয়ানত একটু পুলিশে ইনভেস্টিগেশনে করা
হুম 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 বুঝিব আছে মোৰ এটাই আছে এতিয়া কিবা নাই। আছে। স্বপন দেবনাথ আমি নিচ্ছি। উদাসন স্ট্যাটাস কি নাম? কি নাম? কোন আছে আর আছে দুটো? ইয়াতে মিস করতে করেছো। করে গেছে। কি করা যায়? নাই তো। নাই।
Yes,
I could not find any document of the medical hospital of Bongaigaon.
good or fine, no? Now, what is to be done? I mean, we'll hear you, no doubt, but as it is from what we have seen, there is a very big lacuna in the investigation and in the filing of the charge sheet. In the absence of what treatment was done in the in Dangtol police, Dangtol railway station,
No, sure.
whether it was because the postmortem examination says that it was superficial.
My lord.
Superficial means basically skin deep. It's a skin deep, you know.
My lord.
Once the skin heals, it becomes all right. Now, died due to shock, that's a different thing. But then died due to burn injuries. That
And percentage is
the
not been
percentage
mentioned.
is not there. He says superficial. Superficial is skin deep. Very difficult. Now, and then what about the anomalies in the dates of death? Incident.
Incident, my lord.
In date of the death, the incident, one, two, and I mean 1, 4, and 1, 4, and 2, 4. Which one is the date?
2-4 is the date. 3-4 she was taken there. 4-4 she died. And ward master of MGN hospital informed the police authorities about the date.
Okay, so it is a minor discrepancy
My lord.
because there was a death anyway.
My lord.
But the list of exhibits The prosecution has given only the statements of 164 statements. The FIR, the charge sheet, sketch map made made
PM.
at the
PM to receive.
yes, postmortem report. And also the 164 statement, nothing else. No material evidence, no defense certificate, nothing. So the, first of
What
all,
about your son saying that he saw you pouring kerosene over his mother?
a suggestion was given that he was being tutored.
No, that is a suggestion. Suggestion doesn't mean proof. Suggestion is suggestion. He's denying the suggestion.
Yes, he is denied.
Now,
But-
how old was he?
9 years old, and he also says the date of occurrence was 1st of April.
There might be.
Those are,
And
those maybe can be overlooked.
and a major witness who is the
PW2.
PW2, he also says the date of incidence was 1st of April.
Bapi Chaudhary, allegation is made by the accused person. The victim had an affair with her, him.
But he on oath says the incident occurred on 1st of April, and he every time he was there along with the
He was there along with the victim.
victim.
He was an eyewitness.
No,
He's
Then what
I
do you mean he
heard
was
that.
along?
he heard from others also.
others.
And he taken to went to the New Bongaigaon Railway Hospital. He was there.
Swapna is the neighbor, my Swapna De. She is the immediate neighbor. Her house is situated at
Okay,
some
let us go through all the witnesses.
Yes, madam. PW1, page 9.
Yes.
On oath, she says, I knew deceased Pratima Burman of this case. We lived in the same colony. Her house was situated at some distance from my house. The incident took place about 5-6 years ago. Around 2:33 p.m. on the day of incident, I was sleeping in my house. At that time, an aged woman who lived on rent in the quarters next to that mine called me and said that Rahul's mother, Pratima Burman, was screaming and told me to go there to see as to what had happened. Going there, I found the gate of Pratima Burman's house locked and saw Pratima standing with her son and screaming. Pratima was wearing a petticoat. The people who gathered there broke the lock of the gate and took Pratima to another quarter. She was taken to the quarter of a person by the title of Sheel, who had already left for another place after his retirement. As Pratima felt burning sensations all over her body, a fan was turned on. By calling an ambulance, Pratima was taken to the railway hospital. Pratima's son was crying. After some days, I came to know that Pratima Burman had died. In cross, she says, I do not know how Pratima Burman caught fire. I do not know Bapi Chaudhary. I am not in visiting terms with the accused. So some other lady had informed her that something.
Okay. Yes, we can understand that.
Next, PW2, that is Bapi Chaudhary. Accused Kalyan Burman worked as a khalasi under CNW in railways. On 1/4/2010, I heard that Kalyan Burman's wife, Pratima Burman, had caught fire and she had been taken to hospital. Then I went to the New Bongaigaon Railway Hospital. While Pratima was being taken to Coach Behar for better treatment, she died on the way. I heard from the people that on 1st of April 2010, Friday, accused Kalyan Burman had closed the doors and windows of the room, and thereafter he had set Pratima Burman's ablaze. The accused used to stay in the railway quarters along with his wife, and the incident took place there. I know that the accused consumed liquor occasionally. In cross, the distance between my house and the quarters of the accused is more than 2 kilometers. I know the accused person as he worked in our office. I had never visited his quarter. I do not know as to whose quarters are there near the accused person's quarter. Even after the incident, I had have not visited the railway quarters of the accused. At the time of the incident, the son of the accused was 5-6 years old. I cannot tell the names of the person from whom I heard about the incident. I did not visit the neighbors of the accused to inquire about the incident. I did not even ask anything to the wife of the accused. I do not have personal knowledge as to how the disease caught fire. I just heard about it from the people. So Papi Chaudhary says that he had no visiting terms with the family of the victim, but although he had gone to hospital to see her. No terms with the victim, but although
Okay, the next, carry on.
then the eyewitness is his son. Deceased Pratima Burman was my mother. Accused Kalyan Burman is my father. The incident took place on 1st of April 2010. At the time of incident, we were in railway quarters at Loho Colony, Bangagaon. When we were there, my father often returned home after consuming liquor and assaulted my mother. Around 3 p.m. on 1st of April 2010, my father came in inhabited condition and assaulted my mother. Thereafter, he locked the gate, closed the doors of the house, and set my mother on fire by pouring kerosene on her body. My mother was breathing. The incident took place in my presence. After opening the door, when I called the neighbors, they came and took my mother to hospital. My father fled by opening the door in the backside. My maternal grandparents came, and when they took my mother to Coach Bihar for better treatment, she died on the way. Since after the incident, I have been living in Coach Bihar with my maternal grandparents. Exhibit 1 is my statement given in the court. Exhibit 2 is my signatures. We are two brothers. I am the younger one. At the time of incident, I was about 8-9 years old. At the time of incident, my elder brother was at the house of grandfather at Coach Bihar. My maternal grandparents occasionally visited our railway quarters in Bangagaon. My maternal grandfather was less frequent. My father did not allow my mother to make phone calls to my grandparents. I do not know if prior to that incident, my maternal grandparents have lost any case against the father regarding his tortures on my mother. There were many quarters near our quarter. When my maternal grandparents came to Bangagaon, they did not visit other quarters. My mother could not tell the neighbors that my father tortured her because he did not allow her to talk with them. My father has to perform his duty in the office from 8 a.m. to 6 p.m. My mother cooked in the house. There was no domestic help in the house. Both gas and stove were used for cooking in our house. It is not a fact that at the time of incident, my mother went to light the stove to prepare Horlicks for me, and then the stove got burst and she died. It is not a fact that at the time of incident, my father was in the office. He was not at home. It is not a fact when my father got the information, he took my mother to the railway hospital. It is not a fact that my father informed the maternal grandparents and that on the following day, my grandmother came to visit my mother. I do not know if the maternal grandmother took my mother carelessly without proper facility in spite of the doctor's advice not to take her, and therefore my mother died. It is not a fact that my maternal grandmother is responsible for the death of my mother. It is not a fact that I have adduced falsely today as tutored by my maternal grandmother and others. It is not a fact that the statements of my father closed the door, that he set my mother on fire by pouring kerosene on her, that the incident took place in front of my eyes, that the neighbors were informed and my father fled by opening the door in the backside of the house are false. It is not a fact that my mother died accidentally. It is not a fact I have adduced evidence before the magistrate as tutored by the maternal grandfather and others. It is not a fact that I did not witness the incident. Now the PW4, my lord.
Yes.
The informant and mother of the deceased. Deceased Pratima Burman was my daughter. I solemnized her marriage with accused Kalyan Burman as social customs. At the time of marriage, I gave ornaments, furniture, and rupees 45,000 in cash as dowry. Two sons were born from their wedlock. Since after their marriage, the accused had been torturing Pratima for dowry. The accused did not allow Pratima to talk to us. Around 4 p.m. one day, a person from Bongaigaon informed me over phone that the accused Kalyan Borman had set Pratibha on fire and she was in hospital. He asked us to come if we want to see our daughter. On receipt of the information, some of our relatives and I came. uh, I came and found my daughter in the hospital. Pratima told us that the husband had set her on fire. She told me not to ask the reason as to why her husband had set on fire. After consultation with the doctor, I was taking Pratima to Coach Bihar. She died on the way. She was taken in an ambulance. The doctor referred her. There. I lodged an FIR at the PS in connection with the incident. Exhibit 2 is the FIR lodged by me. Exhibit 2(1) is my signature. The inquest and post-mortem examination of the deceased were conducted in Coach Bihar. Just pausing for a moment. I just want to, there is no indication from whom she was by whom she was informed that her daughter was set on fire. Because she says, a person from Bongaigaon informed me over phone. That person is missing. Next, some of our relatives and I came and found my daughter in hospital. Who are the relatives? No witness has been made as out of those relatives. And then after consultation with the doctor, while I was taking Pratima to Coach Bihar, the doctor referred her to there. No medical documents. And she refers about the inquest and postmortem examination of the disease, which were done in Coach Bihar. These are the 4 things from our deposition. Now in cross, I did not mention in Ejahar that Pratima had told me that her husband had set her on fire. Only after lodging the Ejahar, I heard about that from my daughter. After hearing about it from my daughter, I did not inform the police. PS, I submitted the hospital referral letter at the PS. It is not a fact that I did not submit the referral letter at the PS. See, after lodging the Ejahar, I never visited Bongaigaon. Later says I came to PS police, did not record my statement. It is not a fact that after lodging the Ejahar, I never visited Bongaigaon. Pratima had got married 10 years before the incident. At the time of arrangement of the marriage, in our society, Pati Patra is a kind of agreement, is executed. I did not submit the Pati Patra to the police. I used to visit my daughter's place in intervals of 6 to 8 months. Although I know about the tortures committed by the accused, my lord, the rest, she has nothing, but in her statement on oath, she made 3 indications that somebody has informed who that person we don't know. She came with some relatives. Those relatives are not prosecution witnesses. Then she says that doctor referred her daughter. There is no referral letter as exhibit. No doctor was examined. Now the inquest and postmortem of the deceased were conducted at the Coach Bihar, but the prosecution has miserably failed to brought on record the inquest report, because the inquest report is very clear, although it was not exhibited, but it's very clear that Pratima died on 3rd of April at 7:05 p.m. and the FIR was lodged on the same day at Bongaigaon. That is not possible.
After the death.
After the death. And the FIR does not say that my daughter has died. So my lord, these are the all important. Second IO I have already read. First IO is already read. Medical officer
Already read.
And the PW8 is the bench assistant who took the 164 statement. No other witnesses, prosecution witnesses.
Yes, anything else?
No, my lord, that is, so now some benefit of doubt should be given to the.
Yes,
Lordship, as per the evidence of the informant, she has lodged a FIR on 3/4/2010. And the office concerned have gone through the case diary on the as in person GD entry FIR was registered on 3/4/2010, incident of 2/4/2010, and death of the victim has taken place on 4/4/2010.
no,
And-
just a minute.
My lord.
FIR lodged at what time?
3/4/2010.
That is the
Time,
date.
time. Just a minute, your lordship. 10:30 PM,
3/4/2010
10:30 PM.
at 10:30 PM.
Yes,
As per the CD.
yes.
So incident took place when?
2/4.
Incident at 2/4/2010. At
Yes.
what time?
2:30
2:30.
PM.
At
132.
2:30, Huh?
Yes,
At noon.
132. 132.
1:32. 1:30 to 2 PM.
And she died on 4/4.
And she died on her. That 4/4, what time?
8:15 AM, ward master of MGN Hospital.
8:15 AM.
Yes. Ward
4/4.
master of MGN Hospital informed the police authorities regarding the death. She was brought to.
MGN Hospital.
No, where it's from.
As there were discrepancy, it has become necessary to go through the CD regarding only as regards the timing part, my lord. From the CD, I have noted that.
No, but yes, I know. So MGN Hospital records death at 8:15
AM.
AM for 4/2020.
Yes,
She
it
was
was informed to the,
For
yes,
2010.
She was
broad day. She was brought there.
She was brought dead.
Yes.
dead.
No, date and hour of report. That is 4/4/10/8:15. Date and
Brought-
hour of report.
Brought death. Brought
Yes,
death.
dated hour of
Hour
report.
of-
Yeah.
What is the time of death?
That is 7.
That is given in the inquest report only.
3/4/10,
Ah.
7/5.
That is, but yes,
That's correct.
as per inquest made in Kuch Bihar. But FIR
But your
filed
lordship, the inquest
after
report has
that,
not been
date, after that,
executed.
after that time. FIR
After
filed
that time.
10:30. And PW3 was taking, I mean, the mother was taking the disease to Kuch Bihar.
And when she lost the FIR, there was GD entry first. At that time, she did not die. Subsequently, she died.
How can it be, madam? She died. When did she, you see? She died at what time, according to you? The deceased?
Time since it to be. Lordship, postmortem report doesn't mention about time since date. That column is not there.
But she was brought dead on the next day.
Yes.
How far is this Bongaigaon to Kuch Bihar?
Mm,
So if she had died if she had reached Kuch Bihar hospital at 8:15 AM, that means they must have left early in the morning that
From
on
Bongaigaon?
from Bongaigaon,
Yes,
correct?
yes,
So they left early in the morning.
or late in the evening.
That means late in the evening, how late, how long will it take from Bongaigaon to Kuch Bihar? My sister is telling me that it will take only 3-4 hours.
It's 142 kilometers.
142 kilometers. 140 kilometers, actually 3 hours it should
Right.
be. 3 hours. So 3 to 4 hours with halt and all this stuff. So it cannot be in the evening. It cannot be prior to 10:30 because 10:30 the FIR was filed, where PW4 has said that she is going to take. Going to take doesn't mean taken. So she cannot be in the ambulance and the PS at the same time.
It was written by somebody else, your lordship.
Written but signed by her, no? So she could not have signed it in the ambulance and sent it by someone else. Cannot be done.
Moreover, the inquest report,
No,
although
just
it's on record,
Just a minute, just a minute. Just a minute.
Lordship,
So the thing is that what I'm getting at
my lord.
is that from 2 PM on second till the time she was taken out of the hospital from Bongaigaon. That means for around 32 hours. The disease was in Bongaigaon.
So your lordship meant to say, if I could understand your lordship's query, the doctors in Bongaigaon would have been crucial witnesses to the
Very much,
prosecution case.
Very much.
Because their oral dying declaration is also there,
No,
made
no.
to PW.
But then she was alive for
She
32
was
hours.
alive, she was alive.
And then remember, the burn injuries are superficial, it is not deep. And if you look at the evidence of the doctor,
page 23.
if you look at the evidence of the doctor,
My lord.
he says there was superficial burn injuries of the whole body excepting the face and foot.
My lord.
Now, if there is excepting the face, that means his face was untouched. If it was untouched, she could have easily said what she wanted to say. There was no problem in speaking. Could be, but it says larynx and trachea congested. Nothing about the voice box. Anyway, so
GD entry 59, that was exhibited.
My lord. My lord,
GD entry 59,
GD entry,
exhibit.
I don't think my,
No, madam.
not exhibited.
Any report in the case diary regarding 59?
investigation is very shoddy
My lord.
because there appears nothing to doubt the testimony of the son.
My lord.
But the dates and the timing are not telling with each other. And neither is the medical report,
Lordship.
Really-
Extract is there, extract of GD is there.
GD is there.
page.
It's in the case diary.
Okay. So doesn't really inspire the confidence because the doctor's report lacking in a lot of material particular and the mother apparently taken away the body.
And
From
she has
doctor.
taken that plea. If the victim would have taken Lower Assam Hospital, she would have alive. Accused has taken the plea. But non-examination, although there are material witnesses to the prosecution, whether
That is
the
what-
case
that-
of the
so that is
prosecution will
what,
go,
now
my lord.
material witnesses,
My lord,
if they are not, why weren't they made material witnesses? Why wasn't there a report treatment treatment given in the Dangtol Railway Hospital? Why wasn't that made a part of the prosecution case?
lapses.
So these lapses now appear to suggest that there is something
They wanted to suppress some.
they wanted to suppress. It appears.
Why would this child witness, my lord?
That is the only thing in your favor. If not for the child witness, you had no.
Child witness as well as the mother before her, there was oral dying declaration. So, but
No.
condition of the victim, we don't know about it. Whether she was in a position to give any statement. The state, her state of health.
Where is that, where is there is nothing stated by the Dangtol Railway Hospital doctor
Regarding her health.
that she was conscious, not conscious, she was in a fit state of mind, nothing is there. And remember, she was alive in Dangtol Railway Hospital for around 32 hours. They could have easily made up their mind. If a dying declaration was to be made, they could have always recorded. And it is so surprising that only she heard it, though she was with her relatives, with the other doctors. There's something that is only
Missing.
because only that boy's testimony appears to be in your favor.
That is enough, I think, madam.
Appears to be, I said. Appears to be. I didn't say it is in your favor. Appears to be.
Why will he, I have the judgments, the witness of that age. Lordship. Lordship, I have got the judgment, I will show it to your lordship. The Supreme Court has observed, my record.
This
As
is
in a
the-
child
No, you
witness.
see, the other issue is actually whether the person had really died due to the burns.
Lordship. But lordship,
Whether-
at the
you see,
tender age,
Whether that deceased had died due to the burn suffered by her. Why are you hiding the inquest report made by made in Puj Bihar? Why are you not exhibiting?
lordship, but one factor, lordship will keep it in mind. One hand victim is the mother, other hand accused is the father. And Honorable Supreme Court has observed at the tender age, child would be incapable of nurturing grudge against accused.
No, that we accept. That is why we are saying that it appears that, but then the other factor remains whether that deceased really died due to the burns. Was that the cause of the death? Because
At this
The
stage, also, your
doctors-
lordship, if you.
doctors
sends
postmortem-
back,
no, but what will the trial court do?
13 years have gone by. Date of occurrence is 2010.
What can be done? Nothing.
No, if the doctor of that medical hospital.
But he's not made as a prosecution witness in the charge sheet.
Still then your lordship may do so. For the
And
edge of
then-
justice.
And then the medical report,
Yes, along with the medical report, he may be summoned as a witness by the learned court below.
what about the inquest report? Why is it not been, why should it not be exhibited then? Why? It is your document.
My document, but it goes in against me if your
Then-
lordship considers it.
then-
But it was not exhibited, so your lordship will not take into
If
account.
it
of
goes
that.
against you, and you don't want to
As it
exhibit,
is, that discrepancy is regard the date, my. Only date.
that is, it. So
This it is done, but
Page.
before it came.
inquest-
Non-duty examination, the body and declared.
inquest report is what page?
My lord.
Inquest 68.
68.
It's 61 second. row. It could be learned
We could learn that.
on 3/4 at about
Brought to-
19.75 hours at the end of the time. They take the patient with the body and declared.
So as per his knowledge, it was brought, the body was brought
On
To-
3/4.
to Kuch Bihar on 3/4 at 7. At
Yes.
7 o'clock, 7 PM.
From MGM hospital.
Brought to MJ.
Brought to MJ hospital from Bongaigaon.
That is
But then the FIR was filed at 10:30 on the same night
Previous-
in Bongaigaon.
Previous night.
No, on
I
third,
don't know, on 3/4.
Three.
FIR was filed on 3/4. FIR was not filed on 2/4.
Yes, yes. Date of incident is 2/4.
So FIR was filed on 3/4 at 10:30
My lord.
after the death. And PW, the mother is saying, I am planning to take her to Puj Bihar.
Yes, yes. That is your lordship's query on the other day. So I made it, lordship, I requested your lordship to provide copies.
So still no answer. That inquest report is not in your favor. That is causing all the trouble. That's why you don't want to bring this fact to the for the consideration of the court.
For learned court below, they could have made the endeavor, your lordship, they
Well,
should
they-
have.
they
we
should
would
have, they should have,
insisted upon,
They
my
should
lord.
have, but
Yes.
then they
They
have
could
not
not be
done.
mute spectator. my lord.
Now what to do? We cannot now, act like an ostrich.
Lordship, but because of the irregularity committed by learned court below as well as the investigation agency, whether your lordship at this stage also your lordship may taking into account all the factors, evidence on record may still.
You see, the problem is, this event occurred in 2010. Will the doctors be still available? Will the reports be still there with the hospital?
13
When
years
they have
gone
not-
by.
When he was examined, already visited
Oh,
the doctor, the medical officer.
no, I'm talking about downtown.
Downtown.
Downtown. We do not know. Very difficult.
Whether it was put to the person concerned, whether the query made by your lordships were put by the defense, my lord.
No, but then it has come out now, it's part and parcel of the trial. In the first, in the first appeal, we can all, he can
Yes,
bring
yes,
up
yes.
this.
Appreciate and reappreciate.
So. Very difficult, I don't think it'll serve any purpose by remanding it. We are trying to find a correct decision.
already he
Just
has undergone
acquitted.
13 years imprisonment.
He's still in prison. Okay, right.
Manex?
13
13
years.
years.
13 years.
Heard Mr. Edhar, learned amicus curiae, and Miss B. Boyan, additional PP. This appeal has been preferred against the judgment dated 20/05/2019, passed by the Court of the Sessions Judge, Bongaigaon, in Sessions Case number 120 (BGN) /2015, by which the appellant has been convicted under Section 302 IPC and sentenced to undergo wait, 302 IPC and 498 IPC and sentenced to undergo rigorous imprisonment. No, and to undergo imprisonment for life with a fine of rupees 5,000 in default, imprisonment for 6 months for his offence under section 302 IPC, and to undergo rigorous imprisonment for 3 years with a fine of rupees 1,000, in default, imprisonment for 1 month under section 498A IPC, capital A. on the next para, on the ground that the appellant had killed his wife by pouring kerosene over her and setting her ablaze. Full stop. The prosecution case in brief is that an FIR dated 3/4/2010 was submitted by prosecution witness number 4, bracket PW4, who is the mother of the deceased victim and mother-in-law of the appellant. Where have I said? Just read it once again. The prosecution, the FIR dated 3/4 was submitted, no? Comma, at 10:30 PM. The FIR is to the effect that the appellant used to torture the deceased, demanding dowry. It further states that on 2/4/2010, PW4 came to learn that the appellant had demanded rupees 10,000 in cash from the deceased. As the deceased refused to give money to the appellant, the appellant poured kerosene on her body and set her on fire at around 2 PM, with an intention to kill her. The FIR further states that the deceased was undergoing treatment at Dangtong Railway Hospital and that PW4 was thinking of taking her to a nursing home in Cooch Behar for better treatment. Full stop. In pursuance to the FIR, Bongaigaon, Bongaigaon PPGDE number 59 dated 3/04/2010 and Bongaigaon PS case number 136/10 under section 498 bracket A IPC was registered. During the course of the investigation, the IO bracket PW, the first IO bracket PW5 no,
PW6.
PW6 is the first IO,
First
the
IO.
PW6. No, but what have I said during? I said, no, don't say during, just say after completion of the investigation. The first IO bracket PW6 submitted the charge sheet on having come to a prima facie finding that the appellant was guilty of having committed offense under section 302 and section 498 IPC. 498A IPC. Charges under section 302 and 498A IPC were thereafter framed against the appellant, to which the appellant pleaded not guilty and claimed to be tried. Yes. Next paragraph. In the trial proceedings before the learned trial court, 8 prosecution witnesses were examined. Yes, sir. The appellant was also examined under section 313 CRPC. In which he denied having any involvement in the murder of his wife. No, in the death of his wife. So the learned trial court thereafter came to a finding that the appellant was guilty of having murdered his wife by setting her on fire. And also came to a finding that the appellant was guilty of the offense under section 498A IPC. Accordingly, the appellant was convicted under section 302 IPC and 498 IPC and sentenced accordingly, as indicated in the foregoing paragraphs. The appellant's counsel submits that the a reading of the evidence of the witnesses, a reading of the evidence of the witnesses vis-a-vis the documents, the other documents on record would go to show that there were discrepancies not only with regard to the date of death of the deceased, but also with regard to the time of death of the deceased. He also submits that the prosecution has deliberately not exhibited the inquest report which had been made in Cooch behalf, as the same would contradict the contents of the FIR. And would also show that the prosecution case against the appellant was not believable. Full stop. The next para, the learned amicus curiae submits that while the deceased had been undergoing treatment in Dangtol Railway Hospital, Bongaigaon, before being taken to Kuch Bihar for treatment, comma, the prosecution has not produced any doctor or medical certificate with regard to the treatment being given to the deceased in Dangtol Railway Hospital, Bongaigaon. He also submits that the maker slash author of the inquest report was not made a prosecution witness and examined in the court. Anything else? Next, Miss B. Buyan, the learned additional PP. Submits that. Acha, one more thing. And the learned amicus curiae also submit that that PW 1 and 2 had clearly stated in their evidence that the deceased had died on 1/4/2010.
2 and
Why-
3.
2 and 3, 2 and 3. While the case of the prosecution was that the appellant, that deceased had died on 2/4/2010.
The incident took place.
And I had that the incident took place, sorry. What have I said? Just read. Now that the incident had taken place. That the incident of setting the deceased on fire by the appellant had taken place on 1/4/2010. Comma, while the prosecution case was that it had taken place on 2/4/2000. He accordingly submits that in view of the major discrepancies in the testimony of the witnesses and in the documents relied upon by the prosecution, comma, the impugned judgment has to be set aside and the appellant acquitted of the charges, of all the charges framed against. Next paragraph. Ms. B. Buyan, the additional PP submits that the dates, that the date of the incident has been wrongly been made by PW 2 and 3 in their testimony. Comma, as the incident took place on 2/4/2010. However, the said discrepancy is a minor discrepancy and does not go to the root of the prosecution case. He submits that that the evidence of PW2, who is not only an eyewitness, comma, but also the son of the deceased and the appellant, should be believed, with regard to the fact that the appellant had set fire to the deceased. So she submits that there is no, there can be no reason, there can be no ulterior reason for a young boy of 6 years, 6 years or 5 years?
9 years.
Huh?
9 years.
9 years at the time,
9 years.
of 9 years, to make a false allegation against his father with regard to the offense in question. What did she say? What else did she say? I don't. So her two right hand women were there listening and keeping track of all it was said. You don't remember what she said? Gone in through one ear, gone out the other. Yes, yes. Okay, sit down, no problem. Uh, The additional PP submits that the PME report, the post-mortem examination report, having submits that the post-mortem examination report and the evidence of PW7, who had authored the PME report, having clearly stated that the a deceased had died due to the shock, due to shock. From the burn injuries sustained by the deceased, which was ante-mortem in nature, the guilt of the appellant in causing the death of the deceased had been proved. I think that's all she said. Nothing more. Next. She accordingly submits that though there are minor lapses in the investigation and minor discrepancies in the testimonies of the witnesses, the same can be overlooked by this court as it does not go to the root of the prosecution case. So accordingly, the impugned judgment of the learned trial court should not be interfered with. We have heard the learned counsels for the parties. Yes, before that, what are your points? What you said? One is that there are minor discrepancies in the evidence
Minor.
and in the
It
document.
hasn't gone into the root of the prosecution. case.
Then one, we have said that the examination of the doctor and the PME report proved that the person had died due to the shock from being
Superficial
burned.
damage.
From being burned. The further, what else did we say? That the
Lordship, the evidence of the child witness to enough,
that we have written also.
yes. Already written, your lordship, and your lordship, there's not, why the child of tender age,
That
would-
was said, why
yes.
9 years?
yes.
Hmm.
9 years.
There
There's
was no
Supreme Court
reason to
6
give a
years.
false
Yes,
allegation.
Yes. That too against his own
that's-
father.
That's all.
And irregularities here in there, in
Huh?
lordship, there are irregularities there in their discrepancies, which can be overlooked.
That was said,
My lord.
covered. Okay, we have heard the learned counsels for the party. The FIR submitted by PW1, not PW4. States that PW4's daughter had been undergoing treatment at Dangtol Railway Hospital. And that PW4 was thinking of taking her to a nursing home in Cooch Behar for better treatment. The incident. No, before that it is right. The first issue is with regard to when the incident occurred. As per the evidence given by the witnesses, except PW 1, 2 and 3. And on the basis of the documents on record, we find that the date of the incident, that is the burning of the deceased by fire had taken place on 2/4/2010 at around 2 p.m. At around 1:30-2 p.m. in terms of the case diary, is it?
Person of the
In terms of the yes, I mean.
lordship, in terms of the FIR only, 2 p.m.
No,
around 2
but
PM.
you mentioned 1:30. From where did you mention 1:30?
Lordship.
1:32 you said.
As per version of PW1, it is 2:33. Lordship then. As per version of PW3, it is 3, my lord.
In terms of around 2 to 3, let's say 2 to 3. In terms of the FIR, and evidence of PW1 and PW3. Then next, what have I said about the FIR? Of taking her to a nursing home in Cooch Behar for better treatment. The said FIR was filed on 3/4/2010 at 10:30 p.m. The above facts shows that the deceased was alive and undergoing medical treatment in Dangtol railway station. The Dangtol railway hospital. From 2-3 PM on 2/4/2010 till 10:30 PM of 3/4/2010, that is for approximately 32 hours. Approximately 32 hours. 31/32 hours. Because till 10:30, from 3 to 10:30 will be 7.5 hours. And 10:30 to 10:30, 24. So for 31.5 hours, let's say 31/32 hours. The fact that the appellant had been, the disease has been taken to Dangtol Railway Hospital has been clearly stated in the evidence given by the first IO, that is PW6, wherein he states that the local people, no, don't say that, wherein, that's all, first of it's there. No need of mentioning all that. Next. Surprisingly, no, first of, don't say that. The above, continue, the above being said, PW4 in her evidence has also stated that he had seen her deceased daughter in the hospital while she was alive. PW6, in his evidence, no, wait, huh? PW4, PW4. What have I said? The last sentence? And after consultation with the doctor, while taking while taking her daughter to Cooch Behar, she died on the way. She also stated that the hospital referral letter had been submitted at the police station. She also stated that the inquest and post-mortem examination of the deceased were conducted in Cooch Behar. Surprisingly, the prosecution has not made any doctor who had apparently treated the deceased in Princeton Hospital, railway hospital, and the doctor who referred her for treatment in Coach Bihar Hospital as a prosecution witness. First of further, the inquest report made in Coach Bihar and the referral letter made by a doctor at the railway hospital has also not been exhibited by the prosecution in this case. First up. Next para. Though the inquest report has not been made, but how will it help you? The inquest report does help. How does it help? Page. Inquest report, that is at page 68, okay.
68.
Acha, there's
Date and hour of
though the inquest report has not been made, has not been exhibited by the prosecution, comma, the same is a part of the records. And it shows that the date and hour of death of the deceased was on 3/4/2010 at 7:05 PM. Full stop. The above fact cannot be the exact time of death of the deceased in as much as the deceased had been brought dead to the MJN Hospital, Coach Bihar on 3/4/2010 at 19:05 hours. That is 7:05 PM. However, the fact remains that, no, first of, however, one interesting issue that has arisen on the basis of the non-exhibited inquest report is that that of the date of death, that date of death in the inquest report, that is 3/4/2010. If the inquest report showed that not if, as the inquest report showed that the date of death, the date and time of death of the deceased was 3/4/2010 at 7:05 PM, which was made in Coach Bihar, PW4 had submitted the FIR Thereafter, no, 3 hours later, 3.5 hours later, that is on 10:30 PM, at 10:30 PM, on 3/4/2010, in Bongaigaon, Gustav, which is apparently around 142 kilometers away. Gustav. Next para. The above discrepancies in the date and time of death, coupled with the date and time of submission of the FIR, leaves a big question mark as to when the deceased had really died. And whether at all the appellant, the deceased required any treatment for the burns she allegedly suffered at the hands of the appellant. Full stop. The above question requires us to examine the post-mortem examination report and the evidence given by the author of the same, that is PW7. PW7 has stated that there was superficial burn injuries of the whole body, excepting the face and foot of the deceased. He also stated that on 4/4, no, before that, the evidence of PW7 is to the effect that on 4/4/2010, he conducted the post-mortem examination on the deceased while being posted as the medical and health officer at MJN Hospital, Kuch Bihar. He further states that there were superficial burn injuries of the whole body of the deceased except the face and foot. He further states that no, the further external appearance, no, the further the examination of the deceased also showed that the further examination of the deceased was as follows. Page 23, huh? From red, huh? Red to red. Huh? Next para. In the cross-examination of PW7, he has stated that he had not mentioned the percentage of burn injuries. He further stated that if a patient takes away the patient from the hospital without the advice and consent of the doctor, comma, a responsibility lies on the patient party. Acha, if a patient party takes away, if a patient party takes away, huh? If a patient party takes away the patient from the hospital without the advice and consent of the doctor, responsibility lies on the patient party. He also states that in his report, in his PME report, he had not mentioned. No, in his report, he also states that as per record, the deceased was admitted in MJN Hospital, Kuch Bihar. Admitted. Can a dead body be admitted or will a live person be admitted?
Only live person has to be admitted.
Then his cross says, as per record, the deceased was admitted in MJN Hospital, Kuch Bihar.
Lordship, unless the doctors declare him dead, he cannot be declared as a. He has to, a doctor has to examine him, examine the body, then they declare he is dead, no use.
So if he is brought dead, if a person is brought dead, he's deemed to be alive, according to you.
No, unless the
Till-
doctor declares,
So if a dead body is brought into a hospital, he will have to be admitted first, and
Lordship,
then after only
normal
after.
person like Lordship and myself in the context of we are not doctors. Unless doctor are the authority
No, that is
experts,
why I'm asking you.
Lordship,
I'm not saying that you know the answer. I'm just asking you if you know the answer.
my lord.
If you don't know the answer, that's a different thing. Because the
Because unless the
cross-examination.
doctors declared him dead,
Huh.
Lordship, normal person will not, will be under the,
No, a normal person, that I understand.
my lord.
I'm saying, when a dead body
Dead body is,
taken
there's
to a
no
hospital,
question of admitting a dead
there's
body.
no question.
Yes.
So, his evidence is like this,
My lord.
page 24. Cross-examination. As per record, the deceased was admitted in MJN Hospital, Kuch Bihar. So that means she was alive.
She was alive.
So she was alive.
Because time when he was examined, the body was examined, it's a factor, your lordship, to be taken into account.
When did he examine? Now let us see, when did he examine? Time and.
PM report it might be there. PM
Huh?
report it was-
What was date? What was the date? What was the date?
Page 58,
But when
and
was
PM
the-
report.
What was the time he examined? Time of exam.
Time is not.
Examination 4/4/10, time is not there.
So if he was, you see that now the problem lies, the inquest report was made on third. Inquest report made by Kuch Bihar was on third.
Inquest was made on 4th.
Inquest was made on third.
No, 4th.
Huh?
Page
No, come to
68.
inquest, page 68. Acha, was made on fourth. No, made on, date is not given.
Date is not given.
Date is not
Date
given,
and hour of date 3/4.
but date and hour of date is given as 3/4.
Lordship, reference Kotwali PA so and so dated 4/4/2010. So if the PS case is,
Four,
referred
four.
PS case is 4, page 68. Third line,
How can it be Kotwali PS case?
4, so cannot be, date cannot be.
You see, one thing is the case was registered by Bogaigaon PS case number. It is not a case under the Kotwali.
Could be had.
It is not under it. I do not know, maybe because of
First,
the
the
inquest
case was
report.
registered.
Huh?
Only interest and the postmortem, that is when the case was.
Yes, it was registered on 4/4. So probably this inquest was made on 4/4,
4, the discrepancy is
but
as
the
noting.
death is shown as 3/4.
3, minor. But original inquest, Lordship, I did not get.
No, now the issue is this, leaving this inquest aside,
My lord,
if the deceased had been admitted to Kuch Bihar
my lord,
hospital,
my lord.
then no treatment
She
was
was
given.
brought dead, means on the way she died. On the way to hospital, brought dead, my lord.
No, that is what.
Yes,
According to you, she was brought dead.
yes.
Now, but the
No, as per the
doctor's evidence which you are relying upon, you are saying that the doctor's evidence proves that she died due to the burn injuries. Now, if you are relying on the doctor's evidence, why should we disbelieve the doctor when he says, as per record, the deceased was admitted in MJN hospital, Kuch Bihar. That means not brought dead, alive, and that's why admitted.
brought this one, report of the IO. In his case study, he has noted like that. She was brought in and she died at 8.
Correct.
Yes,
But what about this doctor?
yes, your
So
lordship.
if doctor is reliable or not reliable?
He is reliable because he has deposed before the honorable court in his substantive evidence.
No, but then that is what, in the substantive evidence, he has stated,
And whatever I
That-
made the statement is from the case diary.
no, but then he has said, as per record. Record means hospital record.
Yes.
The deceased was admitted in MJN hospital, Kuch Bihar. So that means we
She
have
was
got to believe
alive.
his statement.
Yes,
What-
she was alive that.
She was alive. But she was alive. She was not brought dead. Now there's again a discrepancy, whether she was brought dead or she was brought alive.
So lordship, the report of the lordship, the Bongaigaon hospital is a crucial one. And non-examination of the doctor regarding the condition of the health of the victim is a lapses to the prosecution case.
A lot. I mean, not done properly, this everything. Anyway, we're just bringing out
I
these,
know.
what have we said? Kuch Bihar. He further states that in his report, he had not mentioned the time since death of the deceased, as well as the age of the burn injuries.
Percentage.
Huh?
Percentage of the.
Percentage of burn.
Age
And age
also,
also.
we have percentage we have already mentioned earlier. Next, the evidence given by PW7 suggests that the burn injuries were only skin deep and not serious. As he has stated that the burn injuries were superficial burn injuries. First off, however, he has also stated that the brain and spinal cord were intact and congested. Full stop. Further, larynx and trachea were congested and contained dark soot particle. It should be SOOT, not SH. SOT. The right and left lung were intact and congested. So it appears, you see, there was the fire, the smoke, all that. And soot particle is there. The way they have written, no, it's. No. Anyway. The above being said, comma, the percentage of burn injuries is not known. Full stop. Further, the deceased appeared to have been admitted in MJN Hospital, Kuch Bihar, while still being alive. As can be deduced from the evidence given by PW7 in his cross-examination. Full stop. The further evidence given by PW7 in his cross-examination seems to suggest that the deceased had been taken away from the railway hospital without the advice and consent. No, just cut that. No need. Cut that. Just- Next paragraph. It is right. The hearing concluded, judgment reserved. Difficult.
Lordship, I understand. But your lordship take into account the evidence of child witness.
But child witness, but there's so many, there are so many other
Discrepancies.
discrepancies. That is the problem. Child witness to no
Whether
problem.
all those discrepancies will take away the evidence of child witness. That your lordship take into account while delivering.
The fact that whether she was actually. You see, that's one thing you're right. The one other thing that has to be considered is whether. Any treatment was given to the deceased in MJN Hospital, Kuch Bihar. By any doctor when she was admitted. And if so, why wasn't the doctor who had attended upon her been made a witness? That's right. Lot of discrepancies, I don't know.
Yes.
Will decide.
Malad will consider that he's for 13 years has already elapsed. He's inside.
13 years, your lordship may consider that aspect because 13
Already
years he is
13
already
years
behind the bars.
behind
He'll be, no, we are not on 13 years or 10 years or 20 years. we're just on whether
And the merit of the case.
the merit of it. We cannot go on that. That cannot be a ground to, of course. Well, the only thing is we have got to see that I mean, it has been proven beyond all reasonable. There has to be some definiteness. Some kind, but if there are too many holes, then cause for. Yes. What? That's still 5 minutes. Huh? Huh? So, two, okay. Yes, so we've got one item.
That matter where Calcutta advocates were supposed
Yes,
to.
yes, madam, what?
And they said that they have already booked their tickets on 31st, so they will stay another day. So second, they are agreeing,
Okay.
2nd of August.
Second, huh? I'll tell the lucky, no? And any other matter? There are matters.
Anjay Das is there.
Oh, okay. At last. At last we meet face to face.
Very busy advocate.
Huh? Busy advocate.
No. Sometimes in the court below, witnesses turn up and official witnesses, it is very difficult. Because they cannot also wait for longer period of doctors and I was.
Maybe too busy.
No.
No. At two then.
Match. Wait, is your lordship? Well, the appellant before your lordship has been convicted under section 302, my lord. And he has been sentenced to undergo rigorous imprisonment for life. And to pay a fine of ₹5,000. My lord, he is in detention since the date of judgment 2019, of the year 2019. Yeah, my lord, 21 prosecution witnesses have been examined by prosecution side, my lord. And appellant before your lordship examined himself as one witness as DW, my lord. And by not going through the paper book, my lord, it appears that there are 4 numbers of eyewitnesses, my lord, of the alleged incident, my lord, in my humble understanding. And my lord,
Who are those eyewitnesses?
my lord, PW, with all respect, my lord, 2, 3.
Two,
Yes, 2,
2, 3, 8 and 16, my lord.
Then,
Then, my lord, if my lord, possibly, my lord, in my understanding, my lord, this is not a case of equital, my lord. So if it can come down, my lord, I will be, my lord, arguing on that point only, my lord. If it is
304,
part one, my lord,
304 part one.
my lord. And especially that exception number one, my lord.
This is that matter where I submitted on the other day where the son of the deceased died because of the bike accident done by the accused because of some accident committed by, what kind of an accident
The
we don't
son
know.
of the deceased
Died.
died.
And because of that, they were carrying that grudge and the mother used to rebuke him off and on whenever she meets him. This is in the statement of the accused. And then one fine day when she was coming from the house of a neighbor, and then she again
What do you mean
rebuked.
son of the deceased died? The son of the deceased,
Son of the deceased was, as per DW, my lord, as per his evidence, he was a pillion rider in the bike driven by the appellant.
Okay.
Somehow he fell down or somehow some accident took place, my lord. And son of the deceased died, my lord, 15 to 20 days back. So for this incident, my lord, the deceased used to always taunt,
rebuke him,
yes, my lord, taunt the appellant, my lord.
so he killed.
So on that day, as per evidence of this appellant, my lord, while he was splitting my lord wood, my lord, this lady came, deceased came, my lord, and shoved him from backside.
Ah.
And in the process, the axe, my lord, he was holding, that somehow, my lord injured her head, my lord.
Somehow, how?
My lord, that is his evidence, my lord. That when he turned, my lord, it,
He turned
my lord,
And
when
the
she saw
doctor,
that-
of course,
and
fracture of
and
the.
he while turning, his axe also
my lord,
turned.
my lord. So it hit the lady, my lord, on her head. And as a result of that, my lord, she died, my lord, because of that injury.
They were fracture
Imagine
of.
if you was holding a hamburger. If he turned, the hamburger would have hit the head.
My lord, my lord,
And he would have gotten a free hamburger.
my lord. This is his case, my lord.
So section 304, part one.
As per my understanding of the matter, my lord, subject to lordship's appreciation, my lord.
Injuries were on the head,
Injuries
fracture of
were-
frontal bones.
Vijay, how many injuries?
My lord, two
One.
injuries, lacerated injuries, my lord, as per PM report.
Two.
my lord. Two injuries, laceration, my lord.
And fracture
Lesser-
only, the fracture of the
Yes.
frontal bone.
How
is
old
the-
was the deceased?
This is was, my lord, around 45 to 50, my lord. And appellant before the lordship at the time of incident, my lord, he was 32, my lord. As per his 313 statement, my lord. So he took the patient, my lord, young one, black man.
Okay, let us see
My lord,
the case.
my lord.
You're for? Any relation to the deceased?
Yes, my lord, aunt. This is was aunt of the appellant.
Deceased
family.
was, no, deceased was aunt of the appellant.
Yes,
No, I'm not on that.
my-
Informant. What is the relationship between the appellant and the appellant or the deceased? What is the relationship? Sister-in-law of?
Informant.
No, informant is the sister-in-law of. At a disease is the sister-in-law of the informant. So, so it was, your brother married the deceased.
yes.
Well,
Naren Boru and the
Yes.
husband of the deceased were brothers.
So so FIR filed by PW,
One, my lord.
your PW1.
My-
PW1 is the brother-in-law of deceased.
my lord.
Okay, appellant is the relationship with the deceased.
My lord,
What?
Nephew.
nephew.
His,
Oh, appellant is nephew of
My-
deceased.
my lord.
So, okay. So the person who died earlier was his first cousin.
My lord, my lord. First cousin.
uncle's son.
Okay, let us go to
My
the,
Lordship will find the affair at page 4, my lord.
where,
May I read, my lord?
yes,
I have the honor to state that at around 11:15 AM on 16/2/17, the abominable accused struck my sister-in-law, Lokhi Burua, on her head with an axe on the road in front of her house, as a result of which she sustained grievous injury on her person. The injured was rushed to Biswanath Civil Hospital for treatment, but she breathed her last on the way to the hospital. I therefore pray to you to take necessary steps in this regard by investigating into the matter and obligement. This is the FR, my lord. And this informant was examined as PW1, my lord, during trial, my lord. That lordship will find at page 9. May I read, my lord?
Page?
9, my lord.
Yes.
I have filed this case. I know the accused person on 16/2/2007. My wife informed me that accused person assaulted Lokhi Burua with axe, and as a result, she sustained grievous injury. And my wife took her to civil hospital, and from there she was referred to Tezpur Hospital. On the way to Tezpur Hospital, Lokhi Burua died. Then myself and my wife brought the dead body of Lokhi Burua to police station, and I filed this case. Exhibit 1 is the FIR, and 1 is my signature. Now cross-part my lord. I filed the case on the next day of occurrence. I have not seen the occurrence. It is not a fact that accused person did not kill Lokhi Burua. He is more or less here, similar. Now PW2, she happens to be an eyewitness. My lord.
She is the wife of PW.
One.
Yes.
I know both the parties. On 16/2/2017, hearing Halla, I came outside from my house and saw the accused person assaulted Lokhi Burua with axe.
Always hearing halla, halla.
My
Uh,
raising hue and crime.
Huh?
Hue and crime.
This translated in this one, now let's see.
Kacha road, halla.
My
Kacha road.
assaulted. May I continue?
Hmm.
Lokhi Burua with an axe. As a result, Lokhi Burua fell down on the ground, and I took her inside her house, and then myself and her daughter took her to civil hospital by auto. When I took the injured Lokhi Burua inside her house, the accused threatened her that he will kill her and all family members. From civil hospital, the injured Lokhi Burua was referred to Tezpur Hospital, and on the way to Tezpur Hospital, the injured Lokhi Burua died. Lokhi Burua died, and then we brought the dead body of Lokhi Burua to police station, and my husband filed this case. The accused person handed over the axe to police, and police seized the axe. Now cross melon, the accused person gave 2 blows with axe on the head of Lokhi Burua. Kolpona, Junaki, and others were present at the place of occurrence. It is not a fact that I have not seen the occurrence. It is not a fact that the accused person did not handed over the axe to the police. The PW3 happens to be the daughter of the deceased, my lord.
Yes.
I know informant Noren Burua and accused Osim Burua. Around 11 AM on 16/2/2017, my mother Lokhi Burua went to house of our neighbor Ram Bhuya. When my mother was returning home, I was on the courtyard of her house. As soon as my mother reached the gate of Dhruvajuti Agavati, accused Osim Burua suddenly hacked my mother on her head with an axe. I was stunned. I went near my mother. I lifted her and took her to the courtyard of her house. A tempo was going along the road at that time. Then my aunt Toramai Burua, paternal uncle Noren Burua, and I took her to Biswanath Sariali Government Hospital on that tempo. But she was not provided treatment there and was referred to Tezpur. But before we could reach Tezpur, my uncle and aunt told me at Balipara that my mother had expired. They accompanied us. Police seized the axe from the accused after I had returned home. Then the police obtained my signature on the seizure list. Exhibit 2 is the seizure list, wherein Exhibit 2(1) is my signature. The axe which I have seen in the court today was used by the accused and it was seized from him. Material Exhibit number 1 is the seized axe. Thereafter, police sent my mother's body for post-mortem examination. Afterwards, my mother's dead body was handed over to us and we cremated it. Police examined me. So cross, my lord. The house of Dhruvajuti Das is in front of our house. The houses of Dhruvajuti, Rambhuya and my aunt Toramai Burua are situated near our house. The house of Aunty Bora is also located near our house. The house of accused person also situated near our house. A policeman from Jinjia PS happened to cross the place of occurrence after the occurrence. When we informed him of the occurrence, he called other police personnel. The other policemen arrived when we were bringing mother to our courtyard. At the time of occurrence only, I was present in the house. My father had gone to the garden. When I raised a hue and cry, the villagers arrived there. Then Jonaki Burua, Bulbuli Bura, Dehmai Bora and others came there. It is not a fact that I have falsely deposed that the accused has assaulted my mother. I put my signature on the scissor list in our house itself when police visited our house. It is not a fact that the accused did not assault my mother and that I have adduced all evidence. Now, PW4 is the husband of the deceased, my lord. He
Is
is a
it, is
hearsay
it required? It's not required.
my lord.
4, 5, 6, 7 not.
My lord. Then, my lord, I will straight away go to 8, my lord.
Mm.
If lordship permits me, my lord. PW8 lordship, you will find it. So page 24, my lord.
PW6, she saw the accused standing with an axe nearby, so that
There is no dispute with regard to
killing.
murder killing.
Then it's not. required.
He is also not taking the plea and there's nothing in the evidence
My lord,
to show otherwise.
my lord.
Not
Oh, my.
required. 8.
PW8, my lord, that lordship will find at page 24, my lord.
Yes.
I know informant Noren Burwa. I know the accused as well. The incident took place at 11 a.m. on 16 to 17. I saw accused Osim Bora striking Srimati Lokhi Burwa with an axe. The incident took place on PWD Road in front of Lokhi Burwa's house at village Tarabari. While I was coming from my garden, I heard a commotion, whereupon I went there and saw the accused armed with an axe standing on the road and Lokhi Burwa lying and writhing on the ground. I saw wound in the head of Lokhi Burwa. Thereafter, people of the neighborhood took her to civil hospital. Later, she was referred to Tezpur. And while Lokhi Burwa was being taken to Tezpur, she died on the way. I went to the hospital when the postmortem examination was held on her body. Now, cross my lord. My house is about 200 meters away from the place of occurrence. My garden is about 100 meters away from my house. When I reached the place of occurrence, I found that a large
It's clear.
my lord.
Mm.
Now, my lord, lordship will have a look at page PW 16, my lord.
Just a minute.
My-
PW9 also has seen the appellant with an axe.
My lord.
PW10 also.
10 also, my lord. Eleven also saw with an axe, my lord. The
My
appellant.
God, everything is against you.
My lord.
What about 12?
12 also same, my lord. Standing with an axe, the appellant. 13 same also, my lord. 14 also same, my lord.
15, he saw accused in an agitated mood.
That's nothing.
15.
15, so that's of no use. Then. Agitated more, that doesn't say anything, denote anything.
Mood near the deceased with an axe.
Huh?
Agitated mood standing near the deceased with an axe.
Okay, with an axe again.
Yes.
With an axe. 16 is an identity.
16 lordship will find it page
16, Yes,
Page 40, my lord. Informant Noren Burua is my father. I know the accused. The incident took place at 10:30 AM.
son of.
This is,
This is my lord.
no,
But you said this is the woman.
son of the, informant,
Informant. Informant, sorry, my lord.
Son of PW1.
My lord.
Hmm.
The incident took place at 10:30 AM on 16 to 17. On the date of incident, while I was returning home from the house of one of my friends, I saw my Borma coming out from the house of Rambuya. Borma was coming ahead of me and I was following her. The accused struck Borma on her head with an axe in front of the house of Subhajyoti Bhagavati. I was in front of the house of Rambuya, and seeing that I entered the house of Rambuya out of fear, Borma died. I came to know that Borma had been taken to hospital. I know nothing more. Police examined me. It is not a fact that I did not see the accused Osim Burua striking my Borma with an axe.
there is a contradiction.
Huh?
Since there is a contradiction, it is not a fact I did not see accused striking my Burma with an axe.
Page.
No, page 41, the cross examination, the line.
Hmm.
Perhaps it is,
It was
No,
suggested.
the
No, it is not the fact that I did not see.
It is suggested. by
The
the-
suggestion.
but then the police must, that this is, the contradiction is brought on record.
Wow.
And now police will go to the IO statement. If we have
No
not
such
stated.
contradiction proved so far as I know, madam.
No,
Seven,
there is no, it did not say, it is stated before the police. He does not say here that he had stated before the police.
It is not a fact that I did not see.
So
accused
he
person.
did not see, that's all.
Huh.
If there
Huh.
is a contradiction
That-
with the examination in chief. Then he did not.
No, what he means, it is not a fact I did not see. That means
That
I
means he
saw.
saw.
Correct.
I saw.
But then he did not see actually. As per his examination in chief, he did not. see.
It did not talk about the police part.
Hmm.
Well, my mistake.
the PW 17 is also on the same line that this appellant was standing nearby with an axe, my lord.
18 also.
18 also.
My lord.
19 is the IO.
19 is the IO, my lord.
He arrested accused from the place of occurrence with the axe.
No.
Huh?
See, X was according to PW 19, my lord, an X was seized from the place of occurrence on the date of incident itself and got it seen in the court. Page 47.
Then
Rest, there is no, my lord, contradiction proved as such, my lord.
PW
20
20
is
is.
also an IO, my lord. He is the ASI, my lord. He immediately went after the occurrence. Case 49. That they married, my lord.
Hmm.
He was on his way and he heard the given threat.
No, one policeman actually was passing nearby, my lord.
He sees the act.
Yes, my lord.
Here, was the accused was shouting that he would assault.
Twenty-one is doctor, what is it?
21 is, my lord, the doctor, my
Doctor,
lord.
doctor.
Opinion of death, my lord. Cerebral vascular accident as a result of head injury sustained, that is head injury, my lord. The cross part, my lord, the injuries were caused by heavy blunt object.
Where does it say heavy blunt object?
Cross part, my lord,
Huh?
one line cross, my lord.
Okay.
The injuries were caused by heavy blunt object.
So you have shot yourself in the foot.
My lord.
Maybe backside of the X.
Not on the, from the starboard side, my lord. No.
Backside.
Now, wait,
The accused.
the accused himself examining as
Yeah.
well. May I read, my lord? I know informant Noren Burua, Lokhi Burua was his sister-in-law, wife of elder brother. Earlier, I had good report with Lokhi Burua. Some time ago, Lokhi Burua's son Bijoy Burua had met with a bike accident. I had hit him as a result of which he died. Lokhi Burua used to abuse me over that issue regularly. Lokhi Burua is my aunt. Lokhi Burua's son had died of an accident some 14-15 days prior to the occurrence. That day I was splitting firewood on the road with an axe. Then Lokhi Burua came there and shoved me from behind. As a result of which the axe hit on her neck. She instantly fell down. Then the public gathered there and seeing the axe in my hand, they assumed that I had intentionally killed Lokhi Burua. I did not kill Lokhi Burua intentionally. Now crossword, my lord. The road in front of my house runs north and south. Our house is located to the east of the road. Our house is about 100 years away from the road. There is no fencing on the boundary of our house. Lokhi Burua's house and that of mine are located on the same line. One can reach my house first. The houses of Diltu, Bhagavati, Rambhuya and others are situated nearby. Lokhi Burua's son was riding pillion on my bike. I did not hit him. The incident took place in the western side of the road. I know Anjan Burua. The incident took place on the road. It is not a fact that Lokhi Burua sustained injury on her head. I know Boroka Burua. It is not a fact that Lokhi Burua did not sustain injury on her neck while I was splitting the firewood. The police seized the axe from the place where it was lying, not from my possession. It is not a fact that I have falsely stated that while I was splitting the firewood, Lokhi Burua showed me, as a result of which the axe hit her on her neck. This is the evidence part.
Yeah.
Now, if my lord, this is version, my lord, because prosecution witnesses and defense witnesses, my lord, they are to be treated equally, my lord. If his version is taken into consideration, my lord,
Whose version?
this appellant, my lord, as BW1, my lord. He virtually, my lord, admitted in his evidence also, my lord, they assume that they intentionally killed Lakhi Burua. I did not kill Lakhi Burua intentionally. Last line of his examination in chief, my lord.
So your case is that not intentionally killed.
My lord.
Why?
My lord, because of his evidence, my lord.
Which evidence?
My lord.
Whose evidence?
My lord, this appellant, my lord, he examined himself as BW, my lord. And lordship will also find that evidence of the doctor, my lord, that my lord, the blunt part of possibly might have been used, my lord, on the X, my lord.
So it doesn't mean that you have to use the sharp part. In fact,
My lord, I understand, my lord.
the blunt part is killed by a lot of tribal communities
My lord,
when slaughtering animals
my lord,
to stun them.
my lord. And only, my lord, lacerated lordship goes to the, my lord, this PM report, my lord. That lordship will find as page 96, my lord.
Page 96.
My lord.
Page 96. Yes.
96, my lord. External appearance, my lord, number one and number two, my lord.
Yeah.
Lacerated wound 2 into 1 cm over right maxilla. Lacerated wound of size 2 into 3 cm over both lateral aspect of frontal labrum, my lord. So if it is lacerated, my lord,
Next, there is a.
So how does it matter? It has to be it's lacerated, so? What you mean to say that it's a minor injury?
no, my lord, I am not saying that.
You mean to say that it, what? What do you
It
mean?
is lacerated, my lord. Lacerated would be, my lord, that
It's cut.
friction sort of thing, my lord. Lacerated means, my lord,
That
Tearing
is,
of
that
the
is, that is,
skin.
that is the outward,
my lord,
outward appearance only.
my lord.
The effect inside is a different thing.
My lord, that is,
When you look at the evidence of someone out there, I don't know who said that I think the
my lord,
cheek was crushed.
my lord,
But there is a fracture of the.
And another thing,
my lord,
you are hitting a woman
my lord,
with an axe.
my lord.
I can understand, supposing we understand your explanation that you turned and suddenly the axe also by itself automatically came and hit
My-
that.
my-
But how was it possible that you had two blows inflicted upon that person? One blow, okay, but there are two blows.
My. My understanding. I understand.
Medical evidence
lord,
prove
yeah.
was a two blows.
My lord,
Okay, because if you did not have the intention, okay, one done in the heat of the moment or due to some involuntary
my lord,
twitching of your muscles or whatever. The second blow could not have been, what happened? First blow, you hit because turning. Second blow, how did it occur?
my lord,
Again, you turned or something.
my lord, kindly appreciate, my lord, because as per the rest of the witnesses, my lord, this gentleman, this appellant, my lord, he was standing nearby the deceased on the road, my lord, with an axe, my lord. My lord, in my humble understanding, had he been the intention to kill, my lord, possibly there would have been further blows upon her, because she was lying helplessly, my lord.
So no,
From that, my lord,
just envision yourself.
my lord,
Envision, let us all envision.
my lord,
Supposing you're standing with an axe.
my lord,
Some lady comes and pushes you from the back.
so,
You turn
my lord,
and your hand also turns
my lord,
with the axe and hits her.
my lord.
Okay, once hit, finish. How did you give the second blow? How do you explain that?
My lord, because that portion of
Or
where
was it that you turned?
above the eyeball, my lord,
Hmm.
this portion, and my lord, this scalp. So possibly this way my lord, the assault has been fallen, my lord. And had, my lord, my submission is this, my lord, the lady is lying, my lord. I am standing nearby the lady, my lord, with an axe, my lord. Had my intention been there, my lord, possibly, my lord, there would have been further blows on her, my lord.
What the blow though?
Further blows. My lord, had the hand in,
Isn't one enough? Why two?
no, my lord, my intention, I am saying, my lord.
Two is more than one.
My lord, I understand, my lord. But this part of this, my lord, injury, my lord, head because, my lord, because of the head injury, my lord, possibly it is,
Can be one also.
it can be one also, my lord, this
One
way.
No, he's saying that he turned and because of that.
That's not-
Anyway, we're
My
just
lord,
trying to
my-
understand, envision
My lord,
Yes.
how it happened.
my lord,
We can understand one blow, supposing we accept his submission that he turned and due to his hand also turning, somehow he hit. But to hit a second time, he'd have to take a very violent,
Yes.
turning around and circle one full 360 degrees, but tack and then
My-
again tack or something. I don't know.
Turning,
I'm trying to,
turning
Turning
around and
around,
the
that
axe hitting, it's
my-
not possible. This is not,
you come to page
Believable.
12.
page 12, my
Yeah.
lord.
page 12, yes. Accused person gave two blows.
My lord, this is in the.
No,
first-
come to the first line, page 12. On top.
Threatened her that he'll kill her and all family members.
My-
Now, when there is a threat,
My lord,
can it be said to be unintentional? This is the evidence that has come.
my lord,
Threatened her that he will kill her and all family members.
my lord,
Then come
This
to the
is-
south, to the cross.
my lord,
Accused gave 2 blows with an
Man.
axe on the head. Mind you, on the head.
my lord.
And then you come to page 23. Second line, he
Right.
was in agitated state.
My lord,
Then you read then the next sentence, the right cheek of Lakhiva got completely fractured. Okay, now come to page 27.
twenty-seven.
Threatening to kill me.
I did not go close to them as the accused armed with an axe was threatening to kill me. Is this the actions of a person who does not have an intention to kill? Then you come to page 50. Third line,
My lord,
I found the accused armed with an axe shouting that he would assault someone.
my lord, that provocation, my lord, because of the, my lord, what he have stated. That provocation might,
Where is that provocation? Sure.
no, my lord, this is evidence.
Huh?
That,
Let us see the evidence.
my lord. DW, page 54, my lord.
Yes,
I know informant Norenbura Lokhiburwa was his sister-in-law. Earlier, I had good report with Lokhiburwa. Some time ago, Lokhiburwa's son Vijay Burwa had met with a bike accident. I had hit him, as a result of which he died. Lokhiburwa used to abuse me over the issue regularly. Lokhiburwa is my aunt. Lokhiburwa's son had died of an accident some 14-15 days prior to the occurrence. That day I was clicking firewood on the road with an axe. Then Lakshmipura came there and shoved me from behind. As a result of which the axe hit on her.
so
on
where
the-
is the provocation?
My lord, because of these words, my lord, Lakshmipura used to abuse me over that
No,
issue
no,
regularly.
but there's no connection. You come to the next page.
My lord,
Then Lakhi Barwa came there and shoved me from behind.
my lord,
The provocation with words was done a few days back, earlier, not on that day.
no, my lord, I have come across one judgment, my lord. 30, section
That it was
300
pent up, it was pent up, huh?
Yes, my lord,
And it was kept bottled up and suddenly exploded.
exactly, my lord. On that line, there is a judgment, my lord. But because of past incidents, my lord,
Division bench of our court.
my lord.
The-
No, my lord, the Supreme Court, my
Supreme
lord, my lord. Because exception was as per that judgment, my lord. If past incidents also, my lord, have taken place, my lord, that may come fall under
But,
the exception.
but then you see, out here, this is a lady, this is a woman. And it is only with regard to verbal abuse.
I understand.
Let us see what was the intimidation or whatever given there in that case, in the
My
Supreme Court
lord,
judgment.
I have, my lord. This is the judgment, my lord. Lordship may come to phase para 11, my lord.
Yes.
KM
Yes.
Nanavati Supra has held that mental background created by the previous acts of the deceased may be taken into consideration in ascertaining whether the subsequent act was sudden and gave provocation for committing the offense. There can be sustained and continuous provocations over a period of time, albeit in such cases, exception 1 to section 300 of IPC applies. When preceding the offense, there was a last act, word or gesture in the series of incidents comprising of that conduct amounting to sudden provocation sufficient for reactive loss of self-control. M. Nanavati Supra quotes the definition of provocation
Before
given
you go further, one thing we should keep in mind,
by minor.
the retaliation should be proportionate to the provocation.
Minor, I understand, my lord. Here also, my lord, in the judgment also, my lord, the deceased, my lord, sustained injury, my lord, multiple injuries on scalp, my lord. Here he used to be, lordship will kindly have a look. Page, my lord, paragraph 3, my lord. 2 lines, my lord, paragraph 3, the next page, my lord. The so and so died due to coma as a result of shock.
No,
in view of-
what was the provocation here?
My lord, here provocation lordship will find with all respect, my lord. 1 second. Paragraph 15, my lord. Paragraph 15, my lord. For clarity, it must be stated that prosecution must prove the guilt of the accused. And that is, it must establish all ingredients of the offense with which the accused is charged. But this burden should not be mixed with burden of accused of proving that the case falls within an exception. However, to discharge this burden, the accused may rely upon the case of prosecution and the evidence that is by prosecution in the case. It is in this context, we would refer to the case of prosecution, which is that the deceased was addicted to alcohol and used to constantly torment, abuse, and threaten the appellant. On the night of the occurrence, the deceased has consumed alcohol and had told the appellant to leave the house, and if not, he
If
would,
not, he would kill the appellant.
my lord.
So
My,
you see the provocation.
my lord,
The provocation is that she would be killed.
no, my lord,
Now,
this is,
what was the provocation? What was the degree of torment or whatever abuse that had been directed in your towards you?
towards me, because my lord.
No,
taunting
but
them-
how? Did she say that she would kill you?
No, my lord, that is not the, my lord,
Okay,
That
carry on
is not
reading,
the
carry on reading.
my lord. A significant observations were needed and not to deny, so my lord. On the night of occurrence, the deceased has consumed alcohol and had told the appellant to leave the house,
No,
and
no,
if
come
not,
to para 12 again.
12, my lord.
That's what you were reading.
Para 12,
Para 11 you were reading, sorry.
my lord.
Para
Para
11.
12 is also important, my lord.
Okay.
11, I will read, my lord.
Uh,
Has held the KM Nanavati Sutta has held that the mental background created by the previous acts of the deceased may be taken into consideration in ascertaining whether the subsequent act caused sudden and grave provocation for committing the offense. There can be sustained and continuous provocation over a period of time. Albeit in such cases, exception 1 to section 300 of the IPC applies when preceding the offense, there was a last act, word or gesture in the series of incidents comprising of that conduct amounting to sudden provocation sufficient or reactive loss of self-control. M. Nanavati Supra quotes the definition of so and so provocation with by Goddard C.J. May I continue, madam?
yes,
Some act or series of acts done by the dead man to the accused, which should cause in any reasonable person and actually causes in the accused a sudden and temporary loss of self-control, rendering the accused so subject to passion as to make him or her for the moment not master of his own mind. Indeed, circumstances which induce a desire for revenge are inconsistent with provocation, since the conscious formulation of a desire for revenge means that the person had the time to think, to reflect, and that would negative a sudden temporary loss of self-control, which is the essence of provocation. Para 12, my lord, the question of loss of self-control by grave and sudden provocation is a question of fact. Act of provocation and loss of self-control must be actual and reasonable. The law attaches great importance two things which when defense of provocation is taken under section under exception 1 to section 300 of IPC. First, whether there was an intervening period for the passion to cool and for the accused to regain dominance and control over his mind. Secondly, the mode of resentment should bear some relationship to the sort of provocation that has been given. The retaliation should be proportionate to the provocation.
Yes, yes,
My lord,
the retaliation should be proportionate
my lord,
to the provocation.
my lord. My lord, that is why, my lord, over a period of time.
Now, what do you understand
My lord,
by the words
my lord,
proportionate?
my lord.
Can you say 1 kg of salt is proportionate to 20 kgs of sugar?
No, 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 it cannot be, it cannot be, my lord,
So
cannot be,
when a person
my lord,
has hit someone with an axe,
my lord,
which, with an intention to kill,
my lord,
as per the evidence of the witnesses,
my lord,
what is the provocation or abuse directed towards that appellant
my lord,
by the deceased, which
My-
is equivalent or proportionate
my lord. My
to
lord,
the act done by the appellant? Was there anything that, yes, you'll be killed, we'll take care of you or something like that? Is there anything?
my lord, it is not there, but my lord, your lordship kindly appreciate, my lord, the appealant before your lordship at that point of time was 32 years, my lord.
And he killed a person of how old?
50, my lord.
50.
55, 50.
And she's a woman.
See the woman, I understand, my lord, but on a regular basis, taunting, my lord, that because of,
I'm not saying anything,
Right.
because the Supreme Court has said that the provocation
my lord,
should be proportional.
my lord. My lord, another paragraph, my lord, para 15, my lord,
Yes.
para 15, my lord, from below, my lord, 7 line, my lord. There was a sudden loss. There was sudden loss of self-control on account of a slow burn reaction followed by final and immediate provocation. My lord.
You have to understand the context in which it was said
I
in this
understand,
case.
ma'am.
Out here,
My lord,
this person who was drunk was threatening this wife that you leave or I will kill you.
my lord,
So there is a threat of killing taking a person's life.
my lord,
And accordingly, killing from this side, provocation, actual effect of killing, there's a proportionate provocation.
but it is slow burn, my lord, that is the
Slow
word.
burn, but it has to be proportionate.
My lord, that is why, my lord, if it is, my lord,
Supposing one fellow comes and tells you, hey, you're a very short-tempered person, unreasonable, stupid person, and he tells you for 20 years.
my lord,
On the 21st year, will you kill him and say, "Yeah, that provocation was proportionate to the act that I had done"? Would you say that?
my lord, because of these past episodes, my lord.
It has to be proportionate.
My lord, that I understand,
The abuse has to be.
my lord, had
Anyway,
he been a, my lord,
Okay, that is where I've heard it.
My
Then
lord.
next.
that is the only one, my lord, because my lord, if my lord, exception one, my lord, comes in, my lord. Otherwise also he is inside for 4 years, my lord,
Huh?
and within the family, my lord. So,
Unfortunately, that that cannot be a ground. The law does not differentiate whether you are a family member or a
no,
not.
no, I understand, my lord. I understand.
Yeah.
But my lord, here, my lord, if he has, what he has said that he showed that, then my lord, the words, there must have been some
See,
words.
there could have been something if there was only one blow given
But-
by an axe to an old lady.
My lord,
But here there is
but
two
this
blows.
portion, my lord, that is why I am saying, my lord.
That is the thing. Imagine your body suddenly turns and you miraculously, by some involuntary action of your muscle, hits the head. Why couldn't have hit the leg or something like that? Why head?
That is why, my lord.
And that also twice.
The intention part, that is why submitting, my lord, because the lady was lying. Had I been the intention to kill her, my lord, possibly there would have been further blows, because suddenly and this portion of the head, my lord, this, my lord, one blow
she died in Biswanath Civil Hospital. Full stop. In pursuance to the FIR, comma, GINGIA, PS case number 17/17 under section 302 IPC was registered. After completion of the investigation, comma, the IO submitted the charge sheet, comma, on finding a prima facie case under section 302 IPC against the appellant. Person. Charge under section 302 IPC was framed against the appellant, comma, to which the appellant pleaded not guilty and claimed to be tried. Full stop. Next para. During trial, comma, 21 prosecution witnesses and 1 defense witness that, comma, that is the appellant himself, comma, were examined by the learned trial court. Thereafter, the appellant was examined under section 313 CRPC. Full stop. The learned trial court thereafter came to a finding that though the appellant had taken the stand in his evidence, that he had unintentionally killed the deceased by hitting her with an axe on her neck, comma, the same had not been done intentionally. It had been done due to the fact that the deceased had shoved him from behind, as a result of which the axe had hit the deceased. Full stop. Just what have I said? Just read that sentence. No, read the sentence, full sentence. Not the entire thing, just that sentence, last sentence. No, the comma, the same had been done intentionally. No, it had been done intentionally, full stop. Thus, the learned trial court came to a finding that the appellant was guilty of the offense under section 302 and convicted accordingly. Next para. The learned counsel for the appellant at the outset submit that there is no denial with the fact that the deceased had died due to being hit by the axe, which was held by the appellant. However, the said act on the part of the appellant had not been done intentionally. He submits that the son of the deceased had died due to being hit by the appellant with a motorcycle, is it? With a motorcycle. Good stuff. In view of the above, the deceased used to abuse and taunt the appellant regularly. On the fateful day, when the appellant was cutting firewood with an axe, the deceased shoved him from behind, and while turning, the appellant's axe hit the neck. Is it the neck? Huh?
Said neck.
The neck of the deceased, which led to her death. He submits that there being no intention on the part of the appellant to kill the deceased, and as the intention to kill the deceased, and as there was a continuous grave and sudden provocation on the part of the deceased against the appellant, the unintentional death, the unintentional act of the appellant in causing the death of the deceased would attract exception 1 to section 100 IPC,
300.
300 IPC. He submits that in view of the sustained and continuous provocation on the part of the deceased against the appellant had unintentionally led to the death of the deceased, and as such, the learned trial court had erred in convicting the appellant under section 302 IPC. He submits that the appellant could at best have been convicted under section 304 part 1 IPC and not under section 302 IPC. That's all. Acha, wait. In support of his submission, that the appellant could have been convicted under section 304 part 1 IPC, he has relied upon the judgment of the Supreme Court in the case of Dauvaram Nirmalkar, DAUVARAM, NIRMALKAR versus State of Chhattisgarh. Criminal Appeal number 1124 of 2022, which was disposed of on 2/8/2022. Next paragraph. Miss S. Jahan, additional PP, submits that there is no infirmity with the decision of the learned trial court in convicting the appellant under section 302 IPC, as the evidence on record does not suggest that the act of the appellant in hitting the deceased with an axe was unintentional. Correct? Postma. She submits that
Judgment Act, given documents, paragraph 12.
submits that the act of provocation and loss of control must be actual and reasonable. Further, when there is an intervening period for passions to cool, comma. Whatever I said, further. She further submits that for attracting the defense of provocation under exception 1 to section 300 IPC, this court would have to see whether there was an intervening period for passions to cool and for the accused to regain dominance and control over his mind. Full stop. Secondly, the mode of resentment should bear some relationship to the sort of provocation that has been given. And the retaliation should be proportionate to the provocation. Full stop. In this regard, she has relied upon the submission of the Supreme Court, the decision of the Supreme Court. Well, the same thing. You have both relied upon the same judgment.
Thank you.
That is why. And That's all. Don't say in this regard. Don't say in this regard, huh? Full stop. Next. I have, no, full stop. Then what else? Any other thing? Nothing. That's all. She submits that as the provocation is not, no, is she submits that as a retaliation on the part of the appellant cannot be said to be proportionate on the part of the deceased, comma. Section, exception 1 to section 300 of the IPC cannot be attracted to the facts of this case. She accordingly submits that the impugned judgment should not be interfered. Mr. And case in her. Learned counsel for the informant also echoes, also reiterates the same submissions as made by the learned additional PP. Next panel, we have heard the learned counsel for the party. The low court, the trial court records show that 21 prosecution witnesses were examined. Full stop. Out of the 21 prosecution witnesses, comma, there were four eyewitnesses, comma, that is PW 2, 3, 8, and 16. Full stop. PW 19 and 20 are both case IOs. Comma, while PW 21 is the doctor who conducted the post-mortem examinations over the dead body. Next para. The post-mortem report of the deceased shows the injuries on the body with regard to wounds, invert comma, wounds, dash, position and character, invert comma slows, and scalp, invert comma, scalp, comma, skull, comma, vertebrae. No, no, and number, and two, cranium and spinal canal, invert comma, amongst others, as follows. So you take at page 96 in red, it is here. Then 97 also in red from here to here. The opinion of the doctor for the death of the deceased was that it was due to cerebrovascular accident, as a result of injuries sustained as a result of the head injuries, which were caused by a heavy blunt object. Next. The question that has to be decided is with regard to whether the petitioners, the appellant's case would come under exception 1 to section 300 IPC. In this regard, the Supreme Court has held in the case of Dauvaram Nirmalkar Supra, has held in the case of K.M. Nanavati versus State of Maharashtra, 1962, Supply 1, SCR 567. That conditions which have to be satisfied for exception to section 300 IPC to be invoked are it is here, page, I'm putting it in red, A to F. Full stop. Subpara, it further held for determining whether or not the provocation had temporarily deprived the offender from the power of self-control, comma. The test to be applied, all the test to be applied is that of a reasonable man and not that of an unusually excitable and pugnacious individual. Pugnacious spelling P-U-G-N-A-C-I-O-U-S, individual. In next para, in the case of Daubaram Nirmalkar Supra, the Supreme Court had held that the question of loss of self-control by grave and sudden provocation is a question of fact. Full stop. And the law attaches great importance to two things when defense of provocation is taken under exception 1 to section 300 of the IPC. Full stop. Then you take from here, huh? Continue from here, read. First, comma, whether there was, two, will continue till provocation. Okay, yeah. Next para. No, just continue, just say. Next para, you say the apex court in the Supreme Court in Daubaram Nirmalkar Supra further held that no, don't say that. Just continue from here to here, from red to red. Okay, that's all. Continue, nothing. Don't say further held, cut that. Then next, on considering the law laid down by the Supreme Court with regard to the conditions required for attracting exception 1 to section 300 of the IPC. With reference to the present case, we would have to see whether the appellant had a time to reflect and cool down from the provocation, and whether the provocation was sufficient to bring about a loss of self-control in the fact situation. Full stop. Further, we would have to see whether the retaliation was proportionate to the provocation. Full stop. Next para, the evidence of the appellant as DW1 is to the effect that there you go. I'll the evidence of the appellant as DW1 is to the effect that the son of the deceased had died due to a bike accident wherein it was the appellant who had hit the son of the deceased with a bike. The deceased, who was the auntie of the appellant, used to abuse him over the said issue regularly. Further, the son of the deceased had died 14/15 days prior to the death of the deceased. On the day of occurrence, the appellant was splitting firewood with an axe, whereupon he was shoved from behind by the appellant, by the deceased. Stop. Not full stop. As a result of which, the axe which she was holding hit the deceased on her neck. Appellant in his evidence states that he did not kill the deceased intentionally. Oh no. I'll have to correct the death part. What do I just read? It was very pillion. Died due to a bike accident, wherein had died they had died in a bike accident where he was riding pillion. Where he was riding as a pillion rider, and the bike was being driven by the appellant. Okay, that is how he died actually. Did not hit. So it hit. So that is the basic thing. That is this evidence. Nothing else.
Nothing.
No sudden provocation except for the shoving and regular abusing.
Mine.
Full stop. Next para. The import of the evidence given by the appellant suggests that the deceased blamed the appellant for the death of her son, as the bike was being driven, as the bike which had met with an accident was driven by the appellant, in which the son of the deceased was riding as a pillion rider. due to the death of the son of the deceased, the deceased kept abusing the appellant and reminding him of the said incident regular. As such, no, in terms of the evidence of the appellant, the continued abuse on the part, the continuous abuse on the part of the appellant led to resentment, which was bottled up inside the appellant. And as a result of it, the appellant had unintentionally killed the deceased. Full stop. Next. On the other hand, the evidence of PW2 is to the effect that he saw the appellant assault the deceased with an axe, and as a result of which the deceased fell to the ground. While taking the injured deceased into the house, the appellant threatened PW2 that he will kill her and all family members. In her cross-examination, PW2 also states that the appellant had given 2 blows with the axe on the head of the deceased. The evidence of PW23, PW7 is to the effect that no, cut that, no need. Evidence of PW9. He was sitting with the deceased in their house at around in their house, full stop. At 10:55, the deceased went out of the house of PW9, stating that she was going to prepare food. On hearing a hue and cry, thereafter, he went inside his house. On hearing a hue and cry from outside, he came out of his house and saw the appellant standing with an axe in his hand and Lucky and the deceased lying on the ground. PW 9 states that he did not further states that he did not go close to them as the appellant, armed with an axe, was threatening to kill PW 9. The evidence of PW '20, IO is that when he arrived at the place of occurrence, along with the DSP, he found the appellant armed with an axe, shouting that he would assault someone. The above testimony of the prosecution witness does not indicate that the appellant's action in hitting the deceased with an axe was unintentional. Further, for a 32-year-old appellant, he was 32 at that time.
My
32-year-old appellant to hit. What is the age of the deceased? The time she died?
45 in our 313.
To hit a 45-year-old woman 2 times with an axe does not appear to be unintentional. Postmortem.
45 as per PM report.
Okay, 45. Just- Next paragraph. The above being said, there is nothing in the evidence to show that the abuse by the deceased upon the appellant is proportionate to the retaliation by the appellant upon the deceased. As held by the Supreme Court in Dauvaram Nirmalkar Supra. Dauvaram Nirmalkar Supra. The retaliation should be proportionate to the provocation. However, the abuse by a 45-year-old lady and the consequent shoving of the appellant by the deceased on the day of occurrence cannot, in our minds, be equivalent or proportionate to the act of the appellant in hitting the deceased twice on her head with an axe. Gustav. That's all? Anything else? Gustav? In view of the reasons stated above, we are of the view that the evidence recorded by the learned trial court does not affect exception 1 to section 300 IPC. We accordingly do not find any ground to interfere with the impugned judgment and order. The appeal is accordingly dismissed. Send back the LCR. Then the fee of the thing.
I'm obliged.
Obliged.
11 and 12. Oh, we do. Then 13. Who is for 11?
11, yes, it is a Pathat matter. I believe so upon Devnath, Ms. Bhuya was there, but today Bhagavati is also not there.
Just give us item 11. Let us see the fact. What is it? Oh,
Now, Ms. Bhuya had
part
prepared
of the three musketeers.
this. Yes. I only told her to leave. I thought this matter will take long, so she left.
Why am I having two paper books? I think one is for your, you got paper book? Or- correct? What is it now? 28, 20. Okay. Okay, who is the council? No one is there.
B. Bhagavati is not here. I
Okay,
didn't see him
this is
today.
this is not a part heard,
Not Pathat, no? Oh, that's it. Not Pathat.
right? No one appears on behalf of the appellant. Accordingly, matter adjourned for a week. Should we say 2 out of the 3 musketeers are
Where are they?
present? 13, yes,
Your Honor, may I kindly pass over this item for a day.
okay,
This is a POXO matter.
okay. In view of paucity of time, the matter is passed over for the day.
Lordship didn't take a break.
Huh?
Lordship didn't take a
I know,
break.
that's why back is slightly more, I think.
Obliged. এখন যে মই লৈ লৈছিলো পিছে থৈ দিয়া আকৌ লৈ লম এইটো 13 এইটো